back at that disclosure, I've tabbed in highlights before your own. I believe it's beginning on the 4th page. James Crosby, expert witness. Knowledge, animal behavior, and law enforcement specialist with knowledge of facts and opinions concerning criminal investigation of shooting, which reflect the opinions of Dr. Catherine Houff. So he was proffered as a rebuttal witness to Dr. Catherine Houff, which is corroborated by his opinion, his primary opinion, when I first opposed him. And if you look at the second deposition, Your Honor, dated September 10, 2019, if you look at page 152, beginning at line 6, or beginning at line 6, with the question, have you formulated any new opinions beyond those expressed when we last met? Mr. Walters withdrew his objection. I said you can answer. Mr. Crosby answered okay. No, I have not formed any new opinions. The evidence presented to me has reaffirmed my opinions as they stand, which opinions involve the rebuttal testimony of Dr. Catherine Houff. Now that we're coming in here today, Your Honor, learning that he may, bless you, that he may testify to new matters, I believe that this case squarely falls under Binger v. King Pest Control. So this needs to be viewed based on a Binger analysis, Your Honor. And in Binger, the Florida Supreme Court held that the trial court has the absolute discretion whether or not to exclude a witness, a late disclosed witness or a non-disclosed witness. And at page 1314 of the opinion, Your Honor, and for the record, it's 401 Southern 2nd, 1310. It's a 1981 case out of the Florida Supreme Court that's been widely cited by numerous appellate courts. At page 1314 of that opinion, it says the discretion to do so must not be exercised blindly. However, it should be guided largely by a determination as to whether use of the undisclosed witness will prejudice the objecting party. Now that Mr. Crosby is coming in, when he was proffered initially as a rebuttal witness, now he's going to come in the plaintiff's case in chief with new opinions that he had not formed during his prior deposition. My client would be extremely prejudiced as a result of the court permitting such testimony or even entertaining such testimony without me having had an opportunity to depose Mr. Crosby on those specific opinions regarding this case and giving me an opportunity to be able to, I guess at this point, defend them through an expert of my own, Your Honor. And the prejudice factor that the Supreme Court looked at, prejudice in this case refers to the surprising fact of the objecting party. I'm surprised. There's no doubt that I'm surprised. You can look at the prior deposition testimony. You can look at the proffer, the expected proffer of what Mr. Crosby was going to testify to. He was clearly going to be a rebuttal witness. He was clearly going to testify in rebuttal to Dr. Houff's opinions. And those opinions that he was going to rebut are set forth in the first deposition on page 48, which he disagrees with Dr. Houff in her opinion that Mr. Deaterly was acting in self-defense. Number one, that's not a proper subject for expert testimony anyway, whether or not somebody was acting reasonable in self-defense. And that wasn't an opinion that we would have or will be seeking through Dr. Houff. And the other opinion was that he was facing a credible threat. That also is not something that we would be seeking to bring in through Dr. Houff, Your Honor. So the knowledge that I have at this point in time is right there. And now that he's coming in to be an expert witness at this point at the last minute, to be testifying during the plaintiff's case in chief, the defendant will be substantially prejudiced by that testimony. We would actually seek to exclude Mr. Crosby from testifying at all in this case, Your Honor.
Mr. Tympanik, I'm curious why he was not listed as a witness in the disclosure of witnesses?
He did. He was, Your Honor. As previously stated by defense counsel, he was listed as a witness. These transcripts are proof that they had an opportunity to disclose them. There's no unfair surprise as it relates to soon-to-be Dr. Crosby testifying as a witness. Additionally, Your Honor, this notion that that he is being offered to rebut, just because somebody says he's offered to rebut doesn't mean this individual is going to be introduced in a rebuttal case, Your Honor. The thinking being is that you can rebut anybody's testimony at any time by simply making your own testimony. I think if I followed defense counsel's argument, I think they were making a Richardson violation, if I'm not mistaken. But part of that is this, as you can understand, this has gone on for years, and as evidenced by going to Jacksonville twice, it looks like, up to physically, to depose this individual over 8 hours. I think that the notion that there's any unfair surprise that he should be excluded based on that is just not the case. They were aware of him. They knew of him for years, and he was listed. The fact that he was not just listed on my witness statement is immaterial because he's been on the witness list for years, Your Honor.
Well, what I'm hearing is that he was characterized as a rebuttal witness.
That's just because, Your Honor, it says offered to rebut the opinions doesn't mean somebody is a rebuttal witness. I've never categorized him as a rebuttal witness, including when I stated he was going to be a witness. I sent defense counsel my trial order, which I sent prior to trial per court's instructions. He was listed on that, and we've talked about it numerous times when we get here. And it's okay, he should be excluded based on unfair surprise. That's just, as you can understand, Your Honor, that is outside the realm of what I believe they were trying to make a Richardson violation. And I think this distinguishable from this actual case they provided to us. But, Your Honor, like I said, their argument is unfair surprise, and as you can understand, there's no unfair surprises. I'm looking at 2 entire binders of depositions.
Well, I'm looking at the supplemental witness and exhibit list that was filed in July of 2019 and has been offered by the defense. It lists Mr. Crosby as an expert witness, and the knowledge summarized is animal behavior and law enforcement specialist with knowledge of facts and opinions concerning criminal investigation of shooting of plaintiff's dogs, in which rebut the opinions of Catherine Haupt, veterinarian, MD. But then when we were preparing for the trial, your most recent witness list, 29 April of this year, makes no mention of it.
Your Honor, like I said, it was an oversight on my part, but it's immaterial. The whole purpose between a Richardson violation is the individual had no notice or knowledge of anything and no way to prepare.
Well, no, the issue is what he's going to prepare for. He may know there's a witness there, but it's the question of what specific area of his expertise he prepares for. It's not just the fact he knows a witness exists, but he has a right to know into what area the witness is going to go, and defense is asserting that is as a rebuttal witness.
And Your Honor, the rebut the opinions of Dr. Haupt. They know exactly what Dr. Haupt is going to say. They have the depositions. He's already said in those depositions how he's going to rebut those notions by Dr. Haupt. They can't come in now, almost 3 years after that, and be like, well, we couldn't prepare for that. Your Honor, there is no unfair surprise. It's written exactly right in there. Animal behavior, law enforcement specialist with knowledge of facts and opinion concerning criminal investigation of shooting of plaintiff's dogs. That was literally what I just said earlier when I talked about why be introduced. And the argument that it was, okay, well, we can't prepare for that, Your Honor. Well, no, it's in these depositions how he differentiates himself from Dr. Haupt and why. I've reviewed them. They're actually in there over the 8-hour deposition that was took in this case over a 2-month period on 2 separate occasions. Their argument just doesn't hold water. It's immaterial that he was not listed on the most recent witness list. When they've heard him in the past, they could expect his testimony, Your Honor, and they've actually deposed him and spoken to him at length. You can't come in here several years later and argue, I had no idea they were going to do this when it says it right here, 3 years ago.
Well, isn't counsel entitled to rely upon your disclosure of witnesses?
And, Your Honor, it's also my disclosure, but also other attorneys' disclosures as well. It's like they knew this was a possibility, Your Honor. This is not out of left field. I did not just add him to the list out of thin air, without deposition, without prior investigation on Friday. He did not. He's been on this list for over 3 years. And they've known about him for 3 years, Your Honor. I understand what defense counsel is saying, but they can't come in here now and say that, oh, we can't be prepared for something that we've known was going to potentially could happen for 3 years. And we're on notice, we deposed, and we actually acknowledge us. And we have 2 binders full of deposition of questions.
Mr. Kessler, your response.
Yes, thank you, Your Honor. So I'm well aware of what his opinions were going to be to rebut Dr. House. I don't know how you can rebut somebody's testimony that has not testified yet. That's new to me. But I knew those opinions, but now he's coming in today saying, I'm going to offer wounds suffered, animal behavior, investigations by law enforcement officers in the shooting, entrance wounds, etc. The opinion was whether or not Mr. Deaterly was acting in self-defense and that he was facing a credible threat. His opinions have nothing to do with wounds suffered, animal behavior, investigations by Leo. Those are new opinions known to me this morning. And if Mr. Timpanic had intended on calling Mr. Crosby as an expert witness in his case in chief instead of a rebuttal witness, it should have been disclosed on his initial witness and exhibit list dated April 29, 2022. It was not until almost a month and a half later, in the Friday before the beginning of trial, that Mr. Timpanic said, well, I'm going to be calling Mr. Crosby. My assumption at that point was as a rebuttal witness to Dr. House, which is what he was disclosed as before. But as we see now he's going to try to present him as an expert witness in his case in chief to elicit opinions that I have had no prior knowledge about. I have had no prior opportunity in which to depose Mr. Crosby on, to do a proper Daubert framework analysis on Mr. Crosby to see if he can meet the reliability factors. I have not had an opportunity to be able to try to find my own expert witness in defense to now his expert testimony or in his case in chief. That is substantially prejudicial to the defense.
Well, I see there's a problem. Mr. Kessler, I'm going to grant your objection to the presentation of him in the direct case. I see that it is prejudicial to you. It was, I think, attorneys, particularly in a case like this, can rely upon opposing counsel's representation of who the witnesses will be. And he failed to include this witness, he says accidentally, but the effect, regardless, on you is that there's no way to correct this in the time we have. I've considered the possibility of perhaps taking his deposition in this week or next, but with the schedule we've got here, I don't see that as a practical alternative. I do think that to the extent that there's evidence that he can give in rebuttal to Dr. Howe, should she testify, and it's otherwise properly admissible, then he can testify in that respect. But I find that this is late disclosure under the Supreme Court case that you've cited, Binger versus King Pest Control. And by the way, there's hundreds of cases after that sustaining the same concept, that the late disclosure of an opinion at this point in the case can be highly prejudicial. And I find that it is, and no alternatives to correct it. So my ruling is that he cannot testify in chief, but he may in rebuttal if his evidence is otherwise admissible.
And Your Honor, note our objection to your ruling for the record.
I assume all my objections that you don't approve of are on the record. Okay. I think the jury's coming in at 10 o'clock. All right, see you then.
All rise. Court to recess. Ladies and gentlemen, we're down till 10 o'clock. You might
record, here we have a jury. Bring him in.
Find homes for all the puppies. She ended up having.
She had 12 puppies, so it made it a little more challenging.
Agree with that. And was a decision made to adopt Candy and bring her into your household?
Not that immediately, but after she had given birth to the puppies and we got homes for them, we did in fact adopt her.
And tell me, how did Candy ever go with you to work?
Yes.
How often did she go to work with you?
Almost on a daily basis, unless there was some reason that she couldn't go, and even then, if I would take her to the office, even if I had to go someplace and leave her there. So she was with me most every day.
And when she was with you, was she with other people?
Yes.
Would that be at job sites?
At job sites and people coming to our office. She was with contractors, subcontractors, my employees at the job sites.
Did she, while going to work with you with all those people, did she ever bite any of those people?
No.
Did she show aggression to those people?
No.
And we're talking, you got her January 2014, correct?
But
What was did you get her approximately a couple years before her death?
Yes, I think it was almost 3 years before her death.
And did you ever take her to Dr. Bonda's office?
Yes.
And describe, was she ever aggressive to Dr. Bonda?
No, she was really a good patient.
Were you ever with her when she had blood drawn?
Yes.
And how did she react when she was getting blood drawn?
She was just cooperative, and just there was no sign of aggression from having blood drawn.
And would she wear a special kind of collar?
We typically would have a pinch collar on her when we took her to the vet clinic. Just would be easier to control her if there were other dogs present.
And would it be fair to say that you were Candy's best friend?
Yes, that would be fair to say that.
Did she ever go boating with you?
Yes.
How frequently did she do that?
Oh, probably once every couple weeks.
And would boating be seen as potentially her happy place?
Yes.
And did she feel safe on your boat?
Yes.
I want to ask you a question. Do you know who Dee Deaterly is?
Yes.
Who is Dee Deaterly?
A friend that I made friends with, who probably in 2002 or 3, and he owned the property that I moored my boat at, and that Candy had opportunity to be on that property as well.
And was Candy ever, did you teach her off-leash commands?
Yes, no really trick commands, but she would, the normal things of sit and stay, come when called, just the normal things that you would teach a dog that was with you a lot.
And did Candy ever bite anyone?
Not to my knowledge.
And did she ever show aggression?
Not to my knowledge, but we didn't know her prior to adopting her or having her, fostering her. So, but since that period, my experience with her was no to both of those questions.
Okay. And did you have an arrangement with Dee Deaterly that you could go onto his property?
Yeah, you've given us permission to have my boat there and to go onto his property.
And how frequently did you do that?
Depending on the time, but I would say sometimes several times a week, sometimes less than that.
Had Candy ever been on the property?
Yes, Candy was with me on the property.
And was she with you a vast majority of those times?
Yes.
And could you describe the property? Was there any fences or gates on this property?
There was a split rail fence around the perimeter of it, and a vehicle and pedestrian gate also.
And had Candy ever been on the property at the same time other people were there?
Yes.
And describe to the jury those instances.
She would just, was usually just with me, but she loved hunting for geckos, so she would be off looking for geckos. And Dee had a company that came in and did lawn maintenance, and so she was encountered those guys when they were working, and was perfectly behaved in that manner.
And she never bit or jumped on any of those lawn maintenance people?
No.
And how frequent, so did you ever go on Dee Deaterly's boat?
On Dee's boat?
Yeah.
Well, he had He had a fairly large hatteras boat that he kept on a dock there. I've never been on it, but I, was with him on boating trips through the Venice Yacht Club, so I was familiar with his boat.
And were you familiar with the defendant, Zach Deaterly, prior to the day in question?
Yeah, we'd met on a couple of occasions.
Had he met Candy prior to the day in question?
Yes.
And did Candy ever show him any aggression?
No.
And how frequent, so to get to your boat, you would, strike that. Did you ever do any work for D. Deaterly?
Yes. As a contractor, I did work on his house on Venice Avenue in Venice. We did work on the cottage at Luella Lane, and a couple of other things. The work at his property in Venice was pretty extensive. It was kind of a three-stage thing. We did a little bit of work for remodeling the dining room and living room, and we remodeled the kitchen and several bathrooms. So,
did you ever do any unpaid work for D. Deaterly?
there were times that I consulted. He'd call me with questions, and I would give him as much time as I could to answer his questions.
And did you ever vacation with them?
Yeah, he had a place in Montana that we went out there on 2 occasions with him, and 2 or 3 other couples that were friends with D as well.
And who else was, tell the jury who were the couples that were there in Montana, to the best of your recollection.
Larry and Sonia, and the Hofstetters were there. And
was Bernice Bell there?
yes, Bernice was there as well.
I know it's going to be difficult, Mr. Jacobson, but I want to take you to November 18th, 2016. Do you recall that day?
Yes.
Could you start telling the jury about how you first got to the property of D. Deaterly on the day in question?
I had driven my truck over there with Candy and had parked it down kind of close to my boat, so I was going to be doing work on my boat to decorate it for the Venice Boat Parade. So that was what I was doing there. Candy was there looking for geckos as well. So that's how I ended up on the property that day.
And describe, you parked your truck, did you park your truck on the property?
Yes, I did.
And was Candy with you?
Yes.
And once you parked the truck, where did you start to walk towards?
I was going down to my boat.
Approximately how far is your boat from your truck, where your truck was parked, to the best of your recollection, given that it's been 5.5 years?
Probably about 60 feet.
Okay. And tell the jury where, once you parked and you started to walk towards the boat, where did Candy go?
Candy was underneath my truck napping after she'd gotten out and went around, looked around a little bit. Then she got under the truck and was napping.
And had Candy been on the property before Unleashed?
Yes.
Did D. Deaterly know that Candy was on the property Unleashed?
Objection calls for speculation. Sustained.
And at some point you begin to walk to your boat. Did you hear a voice call out to your name?
Yeah, I started to walk to the boat. I had gone up to the truck to get something out of it and was walking back to my boat when I heard someone call my name.
And did you immediately turn around and walk towards that sound of your name being called?
Yeah, I turned around and then saw that it was Zach Deaterly, and then I proceeded to walk towards the truck to meet up with him.
And approximately when you first heard your name being called, how far away from Zachary Deaterly were you?
I was probably 100 feet.
And how quick, and you started to, did you walk towards him?
Yes, I started to walk towards him, which was, at that point, he was coming up to my truck, on the front of the truck. So I started to walk towards that area.
Did Candy come out from under the truck?
Yes.
And where did Candy go?
She was barking at Zach as he was walking alongside the truck.
Okay, and let's for the record, could you please point to Zachary Deaterly and identify him with an article of clothing?
He's sitting on the table there with a blue suit on.
And can you identify him, his color tie, roughly?
I can't see his tie at this point. The monitor's in his way.
Oh, Your Honor, do you think that
I don't think there's any question about that.
I understand, Your Honor, but just wanted the record. And what observations did you make of Mr. Deaterly once Candy walked out from under the vehicle?
I remember him stopping and kicking dirt at her until she retreated back under my truck.
And at that, and this is obviously just an estimation, at that first interaction, how far was Candy from Mr. Deaterly?
It varied, but I would say probably 5 feet.
Okay. And did Candy go retreat under the truck?
After he kicked dirt at her, she did.
And did you call for Candy?
And actually, I didn't call for her. I started to walk up to retrieve her from underneath the truck.
Okay. And did she come towards you?
Yes.
And did Mr. Deaterly continue to walk towards you?
He got increasingly closer to me as it developed. Yes.
And is there a point where did Candy eventually come out from under the truck?
Yes.
And describe to the jury where she was located, thinking of a truck, like front, back. Where was Candy when she came out from under the truck?
She was at the back of the truck, kind of where the tailgate flopped down. Is where she had walked out to.
And can you describe to the jury the direction she was facing in relation to the truck? Was she parallel or perpendicular to the truck?
She was parallel to the truck from front to back.
Okay. And did Mr. Deaterly walk towards the back of the truck?
Yes.
And describe where he finally stopped walking to. Approximately how far from Candy was he?
He was probably 6 to 8 feet.
And by this time, you're walking up. Would it be fair to say that you were walking between them?
Yes.
And eventually, did Candy have a collar on?
Yes.
And were you walking up to put a leash on her?
No, I didn't have a leash in my hand, but I was walking up to retrieve her by grabbing her collar.
Okay. And at this point, would it be fair to say, just for to describe to the jury, Mr. Deaterly is to your right and Candy is to your left?
Objection leading.
Sustained.
Mr. Jacobson, describe to the jury how everybody was standing at that point.
Well, we were all in beyond the trailer, the tailgate of the truck. Mr. Deaterly was further to the south, and then Candy, and then me as you worked north to south line behind the truck.
And approximately how far away were you from Mr. Deaterly?
Probably 5 to 6 feet.
And approximately how far away were you from Candy?
A little further, probably 6 to 8 feet.
And what happened next?
I heard 2 gunshots and looked over at Mr. Deaterly, and he had a revolver in his hand, and he had fired 2 shots at Candy.
You didn't, did you see him fire the first 2 shots?
No, I did not.
And why did you not see him fire the first 2 shots?
Because I was going in to retrieve Candy.
And did you know immediately what you heard?
Yes. Could I note that I heard gunshots?
And how did you know they were gunshots?
Well, I've been a gun owner my entire life, and served in the U.S. Coast Guard where we had firearm training. So I'm familiar with what gunshots sound like.
And immediately after the first 2 shots were fired, what did Candy do?
She turned and ran away from Mr. Deaterly and me towards my boat.
And describe to the jury what Mr. Deaterly did after Candy started to run towards the boat.
Well, he still had the gun in his hand, and he was screaming obscenities at me. He called me a fucking moron and a goddamn idiot to bring a vicious dog onto his property.
And was he brandishing the gun when he was saying this?
He had still had it in his hand, and was waving it in his hand to some degree.
And have you received firearm safety training?
Yes.
And was that action, just in your experience, proper firearm safety?
No, it was not.
And immediately following that, did you walk towards the boat? Oh, strike that. What did you say to Mr. Deaterly after he fired the shots?
I said, I was in disbelief. I said, did you just shoot my dog? And he said, goddamn right I did, and I'll do it again.
And how did you find Candy?
Well, I followed her. I saw where she was running towards the boat, so I ran after her, and when I got closer to the boat on the dock, and then on the gunwale of the boat, and then in the cabin of the boat where she ended up, there were, trail of blood. So she was bleeding quite badly at that point.
Can you describe, were you in fear during that situation?
I was in fear that he had not put his gun down and was still brandishing it around while I was going after Candy.
And were you fearful during when he was firing the weapon that it could have been turned on you?
Yes.
And were you fear of your imminent safety?
Yes.
And did you eventually find Candy?
Yes.
How did you track her?
Well, there's a trail of blood going down into the cabin, and I found her lying in the forward cabin area on a pile of life jackets. So I picked her up and removed her from the boat and headed back to my truck.
And describe how she was bleeding. What would you describe the blood loss?
It was a fairly substantial amount of blood that was on the boat and in the cabin and on her as well.
And did you pick up Candy?
Yes.
And where did you pick her up? Where did you go? Where did you begin to go after you picked her up?
Back towards my truck to take her to a veterinary clinic.
What demeanor, while you were walking back to the truck, what demeanor was Candy showing?
She was whimpering in pain and obviously was bleeding still. So she was moaning and whimpering.
Did you make any observations on her body?
No, I didn't take time to do that. I knew that she was bleeding from her body someplace.
And while you were walking back to the car, was Mr. Deaterly still there?
Yes.
Did he say anything to you?
At that point, I don't believe so.
And did you get into your vehicle?
Yes.
And where did you travel to?
There's an emergency veterinary clinic on 41 between Clark Road and Central Sarasota Parkway that I was familiar with because they had taken other dogs there. So I called Cindy, my wife, to tell her what had transpired, and she called the clinic to alert them of my arrival with Candy.
And what observations did you make of Candy while she was in the car, while you were driving her to the Sarasota Veterinary Clinic?
She was still in a great deal of pain and whimpering and crying, lying in the back seat.
And how long did it take you to get to the Sarasota Veterinary Clinic?
It probably took me almost a half an hour because I had experienced a flat tire that I noticed when I got to Central Sarasota Parkway. And I'm assuming that it came from one of the gunshots that Deaterly had made towards Candy that grazed the tire of the truck and eventually had to lose its pressure.
And when you got to Sarasota Veterinary Clinic, what happened next?
They took her into the back room and started administering IVs and medication to elevate her blood pressure, which was low. And I wasn't back there with her, but that's what they described that they were going to be doing.
I have to ask, did you make any observations of Candy fighting Zach?
No.
On the day in question?
No.
Did you observe any observations of Candy jumping on Mr. Deaterly?
No.
Did you have to pay any money at the Sarasota Veterinary Clinic?
Objection, relevance. Overruled.
Yes, I think it was like $2,800, something like that.
And why did you have to pay that amount of money?
Well, that's their policy, that you have to either you have to pay upfront for services that will be rendered, and it's basically kind of a deposit that they bill against.
Describe to the jury why Candy was moved from Sarasota to Tampa.
Well,
Objection, lack of proper foundation, predicate. There's been no testimony that the dog was ever moved from Sarasota to another location.
I'll lay the foundation, Your Honor. That's fine. Was a decision made to move Candy from Sarasota to Tampa?
Yes, because they had a better surgical unit in Tampa to perform an exploratory surgery on her. So the advice from the Sarasota
I'm going to object in that the extent that the answer is going to elicit hearsay testimony, Your Honor.
Is this something he learned from the hospital?
It's just that we're just explaining how she was transported.
He can explain how she was transported.
Yeah. Mr. Jacobson, was Candy transported from Sarasota to Tampa?
Yes, there's a canine ambulance service available that she was put in, and I rode up with her to the Tampa clinic.
And what observations did you make of her while she was lying in the ambulance?
Objection, relevance. Overruled.
She was just still moaning and obviously in pain, whimpering.
And why did you take the ambulance instead of your vehicle?
I just wanted to be with her as much as I could.
And did you get to the veterinary clinic in Tampa? Did you eventually arrive in the
Yes,
vet?
yes, we did.
And what happened from there?
Again, they came out with a gurney and put her on it and wheeled her in, took her into the back room to administer more fluids, I think, and start prepping for surgery.
And did you have to pay money at Blue Pearl, Tampa?
Objection relevance.
Overruled.
Yes, the same policy as the clinic in Sarasota is that they required a deposit. I think that was $5,500 or $5,600.
Okay. And you paid that?
Yes.
And did you, what happened from there?
They evaluated her preliminarily and called in. They have some veterinary surgeons on call for cases like that, so they were going to call them in to do the exploratory surgery from the gunshot wound. And they said if...
Objection, and that this is going to elicit hearsay, Your Honor.
Sustained.
And did they attempt the surgery?
Eventually they did.
And was the surgery successful?
Well, no, they didn't. They discovered the type of wound that happened and logged that into the report, but they were not able to save her.
So, what time did Andy eventually die?
I think probably somewhere around 4 in the morning on the 19th.
Immediately following her death, how did that affect you?
Well, they were kind enough to put her on a gurney and put her in a room where I could stay with her, even though she was dead, and say my goodbyes, which was very difficult, given the violence of her death and the fact that I couldn't do anything about it was troubling to me.
Tell the jury exactly what you were feeling in that moment.
I was feeling shocked and at a loss from my constant companion, which made it very, very hard to accept that.
In the weeks and months and years following Candy's death, did you ever have nightmares about it?
Yes.
Could you describe to the jury what those nightmares were?
Well, it was just a sort of a repeat of her death and Deaterly's involvement in it. It was they were very vivid dreams where I was either chasing after her to corral her, or chasing after Deaterly to deal with him.
Did you ever find yourself wake up screaming?
Yes.
And why were you doing that?
Well, I think it was just a really bad dream, and I was back in that same circumstance trying to resolve it.
And was Cindy ever there with you when you had those instances?
Yes.
And did you ever find yourself crying at the drop of a hat,
Yeah,
thinking about Candy's death?
Yes. It still troubles me.
Do you still have those nightmares?
Yes, less frequent, but I still have those nightmares.
How frequent were they immediately following her death?
Every couple nights.
And is the image of her death burned in your memory forever?
Yes.
Eventually, did you go and see Dr. Edlin?
Objection leading.
Overruled.
Yes.
And why did you go see Dr. Edlin?
Because I was just not myself. I wasn't dealing well with issues of my business, or my friendships, or my relationship with Cindy. Were all being challenged.
And do you feel that you felt different, like a different person after Candy's death?
Objection leaving.
Sustained.
How else did Candy's death affect you?
Just affected my functioning on a day-to-day basis. Her absence in my daily life was very strong.
And when you met with Dr. Edlin, did he diagnose you with anything?
Yes, his diagnosis was PTSD.
And for the record, what is your understanding of what PTSD is? Well, just instead of the acronym.
It's post-traumatic stress disorder, and it happens as I've learned, it happens to people subjected to a vivid memory of such as mine, and also apparently it's common in people that are in armed services that have been in wars.
And just want to take you back. When those first two shots were fired, how far away was Mr. Deaterly from Candy?
Probably 6 to 8 feet.
And how far away were you from Mr. Deaterly?
Probably 5 or 6 feet.
And when he continued to fire after the first encounter, how far away was Candy from Mr. Deaterly?
I'm not sure what you mean by it.
I'll rephrase. After Candy was shot in front of you, how far was she from Mr. Deaterly when he continued to fire?
Objection mischaracterizes the prior testimony of the plaintiff.
He didn't say anything about that.
I'm sorry, Your Honor. When he fired, how far away was Mr. Deaterly after the first encounter when he was shooting?
Well, she had probably run about 15 feet from where he was standing when he fired the other 3 shots.
Your Honor, I am introduced previously, marked, Your Honor, is Exhibit 6, the binder, and I'm just going to hold it up as opposed to giving it around to anyone. Showing defense counsel, which has been previously marked as Exhibit 6. May I approach, Your Honor?
Go ahead.
Jacobson, do you recognize this photograph?
Yes, that's Candy.
And how do you recognize it?
Just that I've known her so intimately that that's her.
And can you describe her status in this photograph?
I believe it's one of the photos taken by the animal services.
Was this after her death?
Yes.
Your Honor, I'm just showing this to the jury. It's obviously previously been introduced into evidence. Mr. Jacobson, earlier I asked you about how often, strike that. There has been questions about your previous marriage. How long have you been married to Cindy Watson?
We got married in 2007.
Were you married before this?
Yes.
And how long were you married to your previous wife?
20-some years.
And eventually was a decision made to divorce?
Yes.
And for the jury, why was a decision made to divorce?
I filed for divorce because my wife had taken up a relationship with another woman.
And is your ex-wife, to the best of your knowledge, still in a relationship with that woman?
Yes.
And how long has it been since you were found out about that affair?
That was in 1997 or 98 when they started the relationship.
And would it be fair to say that it's been about 25 years?
Yes.
And approximately how much, and has your ex-wife remarried?
No.
And approximately in the years following your divorce, approximately how much money did you pay her in alimony?
I paid her up to date, and I paid her over $1 million.
And are you still paying her alimony today?
No, we actually resolved the. I paid her money to buy her out of the agreement.
But would it be fair to say that wasn't before you had already given her $1 million?
Right, I'd already given her $1 million.
When you got to the first veterinary clinic, did you make the veterinarians aware about why Candy was being brought in?
I believe Cindy did, said that she had suffered a gunshot wound.
May I have a moment, Your Honor?
Yes, sir.
To the best of your knowledge, your dog.
There was one bullet.
Moment, just going. Showing defense counsel what's been previously marked as plaintiff's exhibit 13. May I approach? Recognize the photograph.
Yes. Yes. Yes.
Describe to the jury the photographs that I
Describe them?
no,
Well, there are pictures of Candy when she was still alive, and one was in the truck with me, one was in the boat. So they were all pictures of her when she was still alive.
I think I have one final question for you, Mr. Jacobson. Do you think you're ever going to get over the death of your dog?
No.
I'll rephrase. Are you ever going to get over Candy's death?
No, I don't think so.
I have no further questions.
All right, folks, let's take 10 minutes.
Zachary? All rise. Court's in brief recess. the Massachusetts bar exam, didn't you? You were a licensed attorney in the state of Massachusetts, correct? And you were a licensed attorney in the state of Massachusetts all the way up until 2008, correct? And you have your general contractor's license in Florida, correct? And in addition to having the contractor's license, you had your law license in Massachusetts, correct? And you also have your captain's license, correct? And that license allows you to navigate large boats, correct? You don't have any specialty certificates for training animals, do you? Let's talk about your business. You have a business that is known as Island Building Company, correct? And that is your general contracting business, correct? And you are the sole owner of that business, correct? And throughout the course of your business of being a general contractor, you go to work sites, correct? And you tow dump trailers, correct? And you tow dump trailers with your truck, correct? And you tow dump trailers with the truck that was present on the property on November 18, 2016, correct? And in the dump trailer would be all sorts of construction debris, correct? That would include cinder blocks, that would include wood, that would include nails as well, correct? As the sole owner of Island Building Company, you don't routinely file income tax returns, do you? When's the last time you filed an income tax return for Island Building Company, Mr. Jacobson?
Objection, relevant.
So it goes to the financial status of the plaintiff at a time that's relevant to your financial, well, and I'm getting to the financial stressors, Your Honor. Okay. Isn't it true that you have over $1 million tax lien against your business, Mr. Jacobson? Okay, and that's because you don't file tax returns, correct?
I'm not sure.
Okay. But nevertheless, you have over $1 million tax lien against your business, right? You mentioned that you had done work for Zach's grandfather in the past, correct? And that'd be D. Deaterly, correct? And that would include work at the property where the incident occurred, correct?
Yes.
And the work that you did at the property where this incident occurred with Candy included replacing a roof on the cabin, correct?
Yes.
And it also included replacing a roof on what's known as a woodshed as well?
We replaced the roof on a gazebo. I don't know which structure is called what you just referred to.
Okay, so you replaced the roof on a gazebo and the cabin, correct?
Correct. As well as the boathouse.
As well as the boathouse. And in the course of replacing the roof for those three structures, you actually brought in a dumpster and had a dumpster put on the property, correct?
I don't really remember how we did that, but typically that's what we would do.
Okay, so typically you would have brought in a dumpster to put in the construction debris, and that dumpster would have sat at the property while you replaced the roof of the cabin, the gazebo, and the boathouse, correct?
I don't know if it would have worked on those three individual structures.
So it could have been a dumpster that was there for one, and then you brought in another dumpster that was there for the other structure where the roof was replaced, correct? And when you're replacing a roof, it goes without saying that you're pulling up the old shingles off the roof, correct?
Actually, the gazebo and the cottage were wood-shake roof shingles. So they were, and we did pull those old ones up and put flooring strips down.
And there were nails in those, correct? Okay. And when you would have a dumpster at the property, where would you keep the dumpster at?
Well, it has to be accessible to the truck that brought it and picked it up. And you wanted to get as close to the area you're working on as possible. So I don't recall exactly where the dumpster was placed, but it was probably placed where the cottage was probably placed out in front of the garage.
And what about the boathouse and the gazebo?
Those were, I don't remember us having a dumpster for those.
Would you have used?
I'm going to object. This is starting to get completely off topic.
Thinking of what it is. How much further you have?
Not too much. A few more questions. Your Honor. If you didn't have a dumpster for the gazebo and the boathouse, you would have used your dump trailer to haul away the debris, correct?
Probably.
Okay. And where would that dump trailer have been located at the time that you were replacing the roof of the gazebo and the boathouse? You're not sure? Would it have been placed down by where the pump house was?
I don't think so, because we didn't do any work on it.
Okay. So you don't believe that it was parked down by the pump house, correct? Okay. But it could have been. You just don't know, right?
Correct.
When you were replacing the roof of the boathouse and the gazebo, did you ever drop any nails on the ground?
False speculation.
Well, I suspect it's possible, yeah.
Okay. Is it possible there were a lot of nails on the ground? Do you recall there being a lot of nails on the ground?
We're pretty careful about when we strip things off that have nails in them.
Okay. And the work that you did for D. Deaterly, Zach's grandfather, consisted of work at his house in West Venice Avenue, correct? And then out at the property, correct? Any other places?
Well, we did do some repair work for his daughter's property on Chesapeake.
Okay. Any other places? And for this work, D. Deaterly paid you, correct?
I don't know what D's involvement was. We turned our invoices into his company, not
That's D's business, right? Okay. And you never had an invoice go unpaid, correct? Okay. And your arrangement with D was cost plus 15%, correct? And for members of the jury who may not be familiar with that type of arrangement, cost is the cost of labor materials, and then Mr. Jacobson would add his profit on top of that at 15% above and beyond the materials, correct? Profit and overhead above and beyond the cost, correct? And just prior to the incident in this case that occurred on November 18, 2016, weren't you informed by Deaterly family that you would no longer be doing work for D. Deaterly? Okay. After the incident in this case occurred, have you done any more work for D. Deaterly? And prior to the incident in this case, when was the last time you had done any work for D. Deaterly? You have a family history of depression, correct? Your mother was chronically depressed, correct, Mr. Jacobson?
Objection. Assuming facts, not evidence.
Well, I'd like a moment to comment, Your Honor. It is an evidence.
Okay.
Point to it.
But I'll show Mr. Jacobson. We can pull up Exhibit 9, please. So I'm showing you what is a joint Exhibit 9. This is the intake form that you completed for Dr. Matthew Edlund, correct? And this was a series of questions that you had to fill out prior to being treated by Dr. Edlund, correct? Go ahead and turn to the third page of the Exhibit 9, please. And can you go ahead and highlight the family psychiatric history for Mr. Jacobson? In there, you notated that your mother suffered from depression, correct? And ECD as well, correct? You say, this is your writing, correct? You wrote this? And you told Dr. Edlund in his intake questionnaire that your mother suffered from a history of depression. It looks to say ECD. Was your mother hospitalized for depression? You can put Exhibit 9. So safe to say that you have a family history of depression that was with your mother, correct?
I believe that's correct.
Let's talk about Candy. Candy was a pit bull, wasn't she?
Technically, there is no breed called pit bull. It's sort of a common term for looking dog. We did the DNA test that she was majority of her DNA was Staffordshire terrier.
Sarasota Veterinary Hospital, you said your wife, Cindy Watson, called in and told them that you were coming with Candy on the day of the incident, correct?
Correct.
Go ahead and pull up Exhibit 1, please. So any information that Sarasota Veterinary Emergency would have been received from either you or your wife, Cindy Watson, correct? Can we highlight the patient information section, please? And Candy was identified as being the breed of a pit bull mix, was she not? You can put Exhibit 1 down. You often had Candy in a prong collar, correct? Or I think what you identified as a, what was it again? What collar? You routinely had her in a pinch, did you not?
Yes.
Okay. To include veterinarian office visits, correct?
Probably, yes.
Can we pull up Exhibit 15, please? It'd be 14, I'm sorry. And if we can highlight the top section of that exhibit. This is the pinch collar that you're referring to, Mr. Jacobson?
It does appear to be that.
And that collar is in addition to the nylon collar that she already had existing around her neck, was it not?
I don't see a nylon collar.
Your Honor, if you can, I know we can annotate on these screens, so it's easier for the witness if we can turn that on.
Showing the annotations on.
And it's showing a blank screen for everything else.
Maybe you could do the old-fashioned way, just pull out the photograph image and point to it.
What had happened, Your Honor, is you had taken access away from the computer back there. So I think that you have to give access to both. Okay. The annotation. We'll be able to take a break later, and we'll be able to.
Well, it's an easy way. You want to hold it up in front of the jury.
I mean, they can see that. It was just basically for Mr. Jacobson's benefit. Mr. Jacobson, if you look at the exhibit that I'm showing you blown up, do you see the three rectangular right there? Do you see that? You see those?
Yeah.
Those would be the metal associated with the nylon leash or nylon collar that you had on Candy, correct?
Yeah, I'm not sure. There's a lot of stuff going on in that photograph.
Well, there's a lot of hardware in that photograph, isn't there?
Yes.
And isn't it true that you also had a pinch collar on Candy whenever she'd go on boats with you? Or sometimes when she would go on boats with you?
Yeah, sometimes.
Let me ask you this. What was the need for a prong collar on Candy or a pinched collar on Candy when she was on your boat, her safe place she loved to be?
I just think it was probably a way of getting her on and off the boat with being able to hook a lead to the collar. So
you would have a leash on her along with a pinch collar when you would lead her on and off your boat, correct?
Probably.
And that's the 56-foot yacht that you have at the Venice Yacht Club, correct?
Objection, Your Honor, assuming facts not in evidence. And
okay, you want to ask him about his boat?
Sure. Do you own a 56-foot yacht that you keep at the Venice Yacht Club?
objection, relevant.
Overruled.
Yes.
Okay. So you felt the need to have a pinch collar on Candy, and you would have her leashed when you would take her to and from the 56-foot yacht that you kept at the Venice Yacht Club, correct?
More likely it was when I had her on my 30-foot fishing boat.
Okay, let's go ahead and let's pull up Exhibit 13. And we'll go to the fourth page. That's your 56-foot yacht boat in that picture, correct? Okay. If we can go ahead and zoom in on the dog. And that's the pinch collar on your dog on the 56-foot boat, correct?
Right.
Okay. You told people about your dog's aggressiveness, did you not?
I don't recall that I did.
Did you ever tell anyone that to stay away from you and your dog because you didn't know about the history of the animal that you had with you?
I don't recall
the dog was initially taken by Sarasota Animal Services, correct? Or Manatee Animal Services, one of the two.
Yeah, it was one of those two. I can't remember which one it was.
Okay. And you went and you picked the dog up directly from the Animal Services, correct?
Actually, Cindy had done that, and I can't remember if she picked it up from Nate on her Animal Rescue, or from the county.
And Candy was picked up wandering the streets, was she not?
That's my understanding,
And at the point in time that you took Candy in, you knew absolutely nothing about Candy's background, did you?
No.
But despite not knowing anything about Candy's background, you still thought that at some point in time, Candy had been abused, correct?
That was a possible consideration. We never really pursued it beyond just looking at it.
But you based that on the scars on her head and her body, correct?
Yes.
Of which she had multiple, correct?
She had a handful, yes.
Okay. And then you decided to adopt Candy at the end of 2014.
I believe that's the timing.
Prior to Candy coming to you and you adopting Candy, she had not received any specialized training from your knowledge, correct?
Not from my knowledge.
And she didn't receive any training other than training from you, correct?
Yes.
So she didn't go to a animal trainer to be trained after you took her in, correct?
No.
You didn't take her to a specialist in dog training, correct?
No.
And the specific things that she was trained in or that you had trained her in were really three things: healing, coming when called, and staying, correct?
Those would be the primary ones.
And aren't those, I mean, you've owned dogs all your life, correct?
Most of my life, yes.
Isn't that something that you would train your dogs? Those three things throughout your life? Those are basic commands, are they not?
Yes.
So Candy didn't have any specialized training, correct?
Well, she had specialized, in fact, in the sense that it involved those three elements.
Okay, so you consider that to be specialized training. Three basic commands that you've taught every dog, and I think every dog owner would have taught their dogs. You characterize those to be specialized training.
Yeah, well, yes.
Okay. But other than those three things, you didn't give her any other type of specialized training, correct?
No, probably not.
And a requirement of adopting Candy was that she get spayed, correct?
That's correct.
So she was spayed, correct?
Yes.
And she had complications from being spayed, correct?
Yes.
To include internal bleeding, correct?
Right.
And you were deposed in this case once recently, another time about 4.5 years ago. Do you remember those depositions?
I remember them being taken. I don't remember all the details of them.
Okay. Do you remember testifying that Candy would be responsive to you when you called her?
I don't recall that specific point, but that would be true.
So whenever you called her, she would be responsive to you and come to you, correct?
Yes.
And that was all the time, correct? For example, if you told Candy to stay or come, she would always obey and stay or come, correct?
For the most part.
And yet on the date of the incident, you didn't call her, did you?
Didn't call her.
You didn't call Candy. You didn't say anything to Candy on the day of the incident, did you?
I don't recall that, but possible.
If we can play clip 11, please. Or, no, I'm sorry, excuse me, not clip 11. It'll be 10, but don't worry about it. We'll move on. And in November 2016, you had 4 other dogs, correct?
I believe so.
Okay. And Candy would be kept separate from those other dogs. I think we heard from your wife's testimony yesterday, correct?
She was only kept separate from early on during her pregnancy and when she had had the puppies, we kept her separate from all of the dogs because she would be protective of her litter. And after that, she was with most of the other dogs other than the poodle that we had. We were concerned about them wanting to stake out their turf.
So you were concerned about the poodle staking her turf with Candy the pit bull?
Yeah.
You know Zach, right?
I know.
You know of him,
I know
right?
of him.
I mean, you've been friends with Dee Deaterly for how long?
Probably 20 some years.
And throughout that entire time, Zach was his grandson, correct? Yeah. And in fact, Dee Deaterly only had 2 grandchildren, correct?
Yeah.
You're not neighbors with Zach, correct?
Neighbors with Zach?
Do you live next door?
No.
Did you live next door to him in 2016?
No.
Did you live next to the property owned by Mr. Deaterly's family in 2016?
Is that, the answer to that is no. Did not
Okay.
live next to it.
You live about 4 miles away from that property, correct?
Probably.
And in addition to what you told the news agency SNN about Candy not knowing Zach, in addition to that, you can't ever recall ever seeing Zach petting Candy, correct?
No.
And you don't believe that Zach ever interacted with Candy, correct?
Probably not.
And you can't recall any specific interaction Zach may have had with Candy prior to November 18, 2016, can you?
Well, I remember a couple of occasions where I was speaking with Zach while Candy was with me on a leash. That would be about the only time that I spoke with him.
Do you recall testifying January of 2018 that prior to November 18, 2016, that you never recalled having a discussion with Zach about the dog?
That's probably accurate.
Okay. But yeah, your testimony is different here today, right?
Yes.
Okay. Prior to November 18, 2016, you don't ever recall Zach specifically asking you about Candy either, do you?
No.
In your complaint in this case, you allege that Zach was aware of the dog, correct?
I believe so.
And you were aware, or you allege that Candy was familiar with Zach, correct?
I don't recall that, but probably.
Okay. Let's talk about the Llewellyn Lane property and the address in which this incident occurred. That was 220 Llewellyn Lane, correct?
That's correct.
And that's a property in Nokomis, Florida. And describe that property for the benefit of the jury, please.
It's actually there's two parcels I believe involved in it, and a total of about 12 acres, and it is a park-like setting. I mean, he keeps it. At least he kept the place very manicured, so it was a very park-like setting with the 12 acres. Trees were trimmed nicely, and grass was cut.
It was a beautiful place, wasn't it, Mr. Jacobson?
Yes.
Abutted Roberts Bay and the Intercoastal, kind of like a peninsula, right?
Objection, Your Honor, that's not a question.
You would visit the property often, right?
Objection, asked and answered.
Oh, Alex, go ahead.
And how often would you visit the property?
Probably a couple times a week, or at least once a week.
And how often would you stay there when you'd visit?
Depending on what I was doing. If I was picking up my boat to go fishing, it would be one length of time. If I was had work to do on it, it would be another length of time.
On the date of the incident, you arrived at what time in the morning?
I think a little before noon.
A little bit before noon. And then when did this incident happen?
I'm thinking it happened around between 3 and 4.
Did you typically stay for 4 hours on the property?
I don't know if there's a typical standard or not, but on that date, that's the hours that I was there.
And you, when you visit the property, you'd go out and you'd use Dee Deaterly's boat that was there, would you not?
I don't remember if Dee's large boat was still in his ownership when I was there or not. I don't believe so.
Go ahead and pull up exhibit number 13. And we're going to go to the very last page of exhibit 13. Spring loaded, whose boat is that?
That's Dee's boat.
Okay. So you would go to the property, Dee's property, which was very well manicured, very beautiful, and you would use Dee's boat, correct?
On certain occasions, yes.
Okay.
I mean, it wasn't a daily use of his boat.
Did you treat the property as though it was your own, Mr. Jacobson?
No, I didn't assume any ownership rights, but I was careful about what I did there. Because it was such a beautiful spot.
Help me understand this. You're a general contractor that worked very long hours, correct?
Typically.
Get up at 5:30 in the morning and go to work, correct? Come home between 5:30, 6 o'clock at night?
Yeah.
Typically 12-hour days, correct?
Yeah.
And you would typically work 5, 6, 7 days a week sometimes, correct?
Sometimes.
Okay. So help me understand how you still made it out to this property 2 to 3 times every week to spend time out at the property.
I think overall, the times that I spent there were largely on the weekend. And I typically did not work on the weekends with my business, other than minor stuff. So if I was going to the boat, I would be on the property, probably once a week on the weekend.
The incident occurred on a Friday, correct?
I believe so.
Okay, so that Friday was not a weekend day, but you were at the property for several hours, correct?
Yeah, that's because I was decorating my boat for the boat parade.
And how many years had you docked your boat at the Luella Lane property prior to this incident that we're here for today?
I would say 2 to 3 years.
Not longer?
I don't believe so.
And after this incident occurred, you no longer park your boat there anymore, correct?
That's correct.
And you're no longer allowed on the property, correct?
I don't have any interest in going on the property.
Okay. To your knowledge, Mr. Deaterly, Zach's grandfather, D. Deaterly, he didn't own the property where the incident occurred, correct?
I later discovered that there were actually 2 parcels there, one of which was owned by the Deaterly family, and one of which was owned by something called the Spring Release LLC.
Spring Release LLC is who owned the property where the incident occurred, correct? But if D. Deaterly, your friend and Zach's grandfather, had owned the property, you probably wouldn't have sued, would you?
Objection. Calls for speculation.
Sustained.
Let's talk about the split rail fence on the property that you testified to earlier. Go ahead and pull up exhibit number 36, please. Go ahead and turn to the second page. This is the split rail fence at the property, correct?
A portion of it, yes.
You recognize this to be the split rail fence at the property, correct?
Correct.
Okay, and you see the 220 there on the mailbox, right? You recognize that as the mailbox at 220 Luella Lane?
Yes.
If we can blow up the split rail fence, please. When you described a fence earlier, this is the fence you were referring to, right, Mr. Jacobson?
Right.
And this fence doesn't extend all the way around the property, does it?
No, it stops in certain locations where it's too near the water.
Did you ever witness your dog go under this fence?
I'm not sure.
Did you ever have an occasion where your dog had escaped the bounds of the property and got loose?
Objection. Counsel testifying.
Overruled.
I don't recall an instance like that.
Okay, do you know who Brian Williams is? You don't know who Brian Williams is?
Oh, yes, I do know Brian.
He works at the property, correct?
I don't know if he still does, but he did.
He did back in 2016, right? Okay. And you would see him out at this property oftentimes, correct?
Yeah, frequently.
Okay. Did you ever have an occasion when Mr. Williams was on the property with you that he had to help you search for Candy because she got loose outside of the confines of the property?
I do recall that.
Okay. So you recall that incident where Candy got out of the fence and escaped the confines of the property, correct? Okay. You can take exhibit down. Thank you. Go ahead and pull up exhibit 35, please. You can go to, or zoom in a little bit. This is a survey of the property where the incident occurred, correct? Okay. It's in evidence is Exhibit 13. Do you see two separate docks there? If we can zoom in on the docks. Okay. And would you keep your boat at the northernmost dock or the southernmost dock? And if we can zoom back out and go to the second page of that survey. Actually, go ahead and go back to the first page, please. And zoom in a little bit over the pump house or woodshed that's identified. Thank you. Are you familiar with the woodshed? Do you see where it says woodshed there, Mr. Jacobson, on that octagon? You're familiar with that being the pump house, correct? On the date of the incident, where was your truck parked? On that shell pathway? In which direction was it parked? Okay, if we can draw a line there, approximately. Around right there, Mr. Jacobson, or over to the right more? Okay, so that's where your truck was parked, right? To the right of that, where it's notated shell path? Like that, Mr. Jacobson? Okay. And that was the direction that your truck was parked, correct? The property had a wet spot on it, didn't it? Okay. And that low area was right behind where you had your truck parked, right up to the top right of the rear end of where your truck would have been parked on that day, correct? Is that where the wet area was? Okay. So that wet, muddy. So your truck was parked there. Where were you at the time that you heard Mr. Deaterly yell out, "Hey, Rod"? And if we could get something there to mark that. A little farther south of that, Mr. Jacobson? Yeah, a little bit. Right there? About there, Mr. Jacobson. Okay. So if I understand you correctly, your truck was parked where we have that perpendicular line on the shell path. You were located at the southernmost line, and you were walking towards your boat, correct? And then you heard someone call your name, correct? And then you turn around and you saw that it was Zach, correct?
Yeah, I didn't.
And did he continue to walk towards you? And at this time, I believe you testified earlier that at this time, Candy came out from underneath the truck and started barking at Zach, correct? And you witnessed Mr. Deaterly kick dirt at Candy, correct? And did you presume this to be because he wanted to kick her away? Sure. Did you presume he did this to get her away from him? Okay. In fact, you testified during your deposition, did you not, that you believe Zach kicked dirt at the dog because Zach believed she was a threat to him? We can play clip 22. Would there be any particular need for him to have kicked dirt at her to get her away from him?
No, I mean, he obviously felt that her barking at him was a threat to him, which is not the case.
Your dog was not on a leash on the date of the incident, correct? And you and Zach were the only ones on the property at the time of the incident, correct?
As far as I know, yes.
Okay. And this case has been pending now for 5 years, and the incident happened almost 6 years ago. Throughout the pendency of this case, have you learned of anyone else being at the property other than you and Zach on the date of the incident?
No.
Okay. And you had testified earlier that at the time that Mr. Deaterly initially shot at Candy, that you were standing in front of him, but that's not true, is it?
No, that is true.
Okay, so you don't recall testifying during your deposition that when Mr. Deaterly shot the first set of shots that you were standing shoulder to shoulder?
Yes, that's correct.
If we can play clip 76, please. So she was coming to you when Zach shot Candy.
Right. She was approximately, I would say, 10 feet away from him when he shot.
She was. You said she was approximately 10 feet away from you
When he shot her.
when you shot her. And approximately how far away were you?
10 feet. We were literally standing next to each other.
Were you standing shoulder to shoulder at that time?
We were approximately aligned. About like that.
Thank you. Take it down. And then according to your testimony, deposition testimony, when Mr. Deaterly shot the second set of shots, he was facing away from you, correct?
That's correct.
Okay. So at no time did Mr. Deaterly point a gun at you in the course of shooting Candy, did he?
No.
At no time did Mr. Deaterly say, "I'm going to shoot you, Mr. Jacobson," did he?
No.
In fact, you didn't know he had a gun until he shot at Candy, correct?
That's correct.
Did you want to break for lunch, Your Honor? I've got a lot more of cross-examination.
Yeah, come on.
All right, folks, we think this is a good time to break. We're doing pretty good on time. Possibility perhaps running a little late tonight, but doesn't look like it would be late. So, all right, so I'm going to let you go to 1:30 this afternoon, and bailiffs will tell you where to rally, and we'll see you back here at that time. Leave your notes, please, on the, we got your clipboards? Good, okay. Okay, anything until we reconvene?
No. Dr. Morris, after this is complete, Dr. Morris will testify at 4. And would we want to accommodate Dr. Ellis the same, since now we do have the technological capacity? That was one of the issues that you deferred on.
Again, I have to check with IT.
Okay. This would just be the same thing.
You're okay with doing it by Zoom?
Yeah.
And how, you're okay? Just let me see if I can get the technology issues resolved, and I'll see if I can work with you, okay?
Perfect. Thank you so much, Your Honor.
All rise. Court's in recess till 1:30.
trying.
Be approximately where the property is located at 220 Luella Lane, correct?
It appears so.
Okay. And then this spot that I'm circling up here near Gulfgate Estates, that would have been where the veterinarian clinic was that you took Candy to that day, correct?
Approximately.
Okay.
I can't say specifically that that's exactly where it is.
No, but in the approximate area,
Yes.
correct? Okay. And where I'm circling here, do you know that to be Central Sarasota Parkway?
I don't see it labeled, but it appears to be in the appropriate location to be that street, yes.
Okay. So the incident happened with Candy. You got into your truck and you left the Luella Lane property, correct?
That's correct.
And when you left the Luella Lane property, you came to LB Road, correct?
Yes.
And then you would have taken a right on LB Road, which would have taken you to 41, correct?
Actually, I probably took a shorter cut there. If you go down Bay Shore, it intersects with West Laurel. It's just closer to get to 41 than to go out where you're describing.
How many times would you have had to have stopped from the Luella Lane property in 41 if you had taken that Bay Shore shortcut?
There's a
Objection
traffic
calls for
signal.
speculation.
Hold on, no rules. You can testify.
Repeat the question, please.
Sure. You said it does a shortcut. You're familiar with that shortcut, correct?
Yes,
Taken it plenty of times before, correct?
yes.
Okay. So when you left the Luella Lane property and you took that shortcut to 41, were there any places that you had to stop during that distance?
Just when I got to Laurel and 41.
Okay. So you left the Llewellyn Lane property, took the shortcut, got to 41 in Laurel Road, correct?
Correct.
You hit a stoplight at Laurel and 41, correct?
Correct.
At that point in time, you didn't notice that your truck had a flat tire, did you? Where I'm circling in red, that would be where Laurel and 41 meet, correct? Or excuse me, up here. That would be where Laurel and 41.
Correct.
And then at Laurel and 41, you went ahead and you took a left on 41 and started heading towards Sarasota, correct?
Correct.
Did you hit any stoplights?
I don't believe so. I don't believe so, and I don't think I stopped at Blackburn Point intersection of 41. So I think it did not stop until I got to Central Sarasota Parkway.
Okay, so you didn't have to stop until you hit Central Sarasota Parkway. So I'll draw that in purple. You can watch your screen. From the red up to the blue. That's how far you drove without having to stop, correct?
Yes.
That's approximately 8 miles, correct?
I don't know. I didn't measure it out.
And I think the court took judicial notice of the fact that it was 8.2 or 8.3 miles,
Okay.
that distance.
All right.
And you didn't notice for that 8 miles that you had a flat tire, correct?
No.
Okay. And I think what's really important to put into perspective is that this incident occurred in 2016, November of 2016. And how often would you travel 41 going from Laurel up into Sarasota using 41 during that period of time?
Not frequently, but occasionally.
And you were familiar with the construction that was going on 41 at that time, correct?
I mean, the construction at the Oaks area?
Correct.
Yes.
Okay, and that's before Central Sarasota Parkway, correct?
Yes.
And that was a lot of construction where the road was tore up, correct?
It was mostly related to congestion caused by the bridge being replaced.
Okay. So then you get to Central Sarasota Parkway and you hit that red light, correct?
I did have a red light at that intersection, yes.
Okay. From the Llewellyn Lane property to Central Sarasota Parkway, who did you call?
I called my wife and I called Dee Deaterly.
Okay. So you got to the Central Sarasota Parkway, you got to the stoplight, and that's when you believed that your tires started going flat, correct?
Yes.
And then when the light turned green, you still proceeded north on 41 to get Candy to the veterinarian, correct?
Yes.
And at some point in time, you testified during your deposition that the tire fell off the rim.
Yes.
And that you testified during your deposition that at that point in time, you pulled over into the grassy median and continued driving north on 41, correct?
Correct.
Which tire went flat on your truck, Mr. Jacobson?
The right rear.
So if you're going north on 41 and your right rear tire goes out and you're pulling on the grassy median, you would have to take your whole entire truck on the grassy median, would you not?
Yes, I did.
Okay, and you drove the entire grassy median all the way up through, correct? Except there's...
Until I had to cross over to get to the vet clinic, yes.
Okay. And it's your testimony that from Central Sarasota Parkway up to the vet clinic that there is a grassy median all the way throughout that entire distance.
I was so focused on getting to the vet clinic, I didn't really see if it was, that whole area was grassy median or not.
Okay. And then you arrived at the vet clinic, got Candy into the vet clinic, and after she got situated, you went out and you put a spare tire on your truck, correct?
Yeah, it was a fairly lengthy period of time after I took her in there to be sure she was getting care. Then I did change out the tire.
And when you were putting the spare tire on her truck, it was at that point that you noticed that there was some damage to your wheel rim, correct?
Yes,
And despite that damage to the rim, you didn't replace it, did you?
no,
You got a quote for that replacement of the rim, correct?
yes,
But you didn't get that quote immediately after the incident occurred, did you?
no, it was several weeks later.
It's your testimony it was several weeks later that you got the quote?
It was some period of time later, whether it was several weeks or 3 weeks or 4 weeks, I'm not sure.
Was it a year after the incident occurred before you went ahead and you got a quote for the replacement of your wheel rim, Mr. Jacobson?
I guess that's possible.
Let's go ahead and pull up exhibit number 18, please. Oop. If you can go back to the prior exhibit, I have to make a screenshot of it. Sorry. If you can expand it up with the way it was. Okay, if you can go to exhibit number 18, please. And if you can blow up the date on the top right-hand corner of that exhibit, please. Exhibit number 18 is a joint exhibit. That's the quote that you received for the replacement of your wheel rim, correct?
Right,
And you received that quote on November 21st, 2017, correct?
according to this, yes,
And that was a year after the incident occurred, correct?
approximately, yes.
That was after when this lawsuit had been filed, correct?
Can't remember the date of the filing of the lawsuit.
Seeing a copy of the complaint, refresh your recollection as to when the lawsuit was filed.
If it's dated.
Bear with me for a second, Mr. Jacobson. I approach the witness, Your Honor.
This is the last page. No,
But it has a filing date on the top of the first page. Does that refresh your recollection as to when the complaint was filed?
not really. I'm assuming that it's correct, so it probably fits within the scope of when it was.
And that filing date is August 15th, 2017, correct?
Correct.
So this quote was received after you filed your complaint in this case, correct?
It seems that way, yes.
And the only reason why you got this quote was to provide it in discovery, correct?
I don't really recall. I did get it in order to replace it at some point, because I had no idea what the value of it was.
And if you can zoom out and then zoom in to the cost, please. And replacing the rim would have cost you $339.17, correct?
Yes.
And the reason why you didn't replace the damaged rim is because the cost of replacing it to you, as you testified to during your deposition, was pretty substantial, correct?
Yes.
So $339.17 to replace a rim that you allege Mr. Deaterly damaged was too costly to you in November of at least 2017 when you got the quote, correct?
Yes, it appears that way.
Yet in 2016, your business, Island Building Company, had income in excess of $1.5 million, did it not?
Objection, Your Honor, relevant.
It's not in the form of a question.
Okay.
You may ask in the proper
Mr. Jacobson, in 2016, did your business, Island Building Company, have an excess of $1.5 million of income?
I'm not sure without looking at the records.
You're aware of the alimony modification case that you filed, correct?
Yes.
Okay. And you testified during that case, correct?
Yes, I believe so.
Do you recall testifying during a hearing in that case on November 17, 2017?
I don't remember that, the date of it.
Would seeing your testimony from that case refresh your recollection of that?
Probably.
Okay. May I approach the witness, Your Honor?
Yes.
And Mr. Jacobson, I'm just going to give you a second to read through that.
The entire,
Or you don't have to read through it, but you can look through it. And I'm going to direct your attention to page 7 when you're finished. And specifically lines 6 through 9 on page 7, Mr. Jacobson. And let me know when you've had an opportunity to read that.
yes,
Does that refresh your recollection as to the income that your company, Island Building Company, made in 2016?
yes.
And what was it?
$1,768,9.48.
And around the time that you received this quote for the replacement of your rim that you testified was too costly or the cost was substantial, you reported making approximately $21,925 per month, correct?
Probably, yes.
And at that point in time, were you spending approximately $1,500 per month in monthly club dues and memberships?
That I don't know.
If we can pull up Exhibit 20, please. page 5. Or, if you could highlight the monthly club dues and membership section, line 78. And Exhibit 20 is a financial affidavit dated November 10th, 2017, from your alimony modification case. And on this financial affidavit, you reported spending $1,500 per month in monthly club dues and memberships, correct?
Correct.
And were you also spending $300 per month in monthly vacations?
Probably.
If you can scroll out, be line 82. Is that correct?
Yes, that's what it says.
And at the same time, you had 2 boats, one that was 30 feet and the other 56-foot one that you described earlier, correct?
Correct.
And at the same time, you were spending $3,243 per month towards that 56-foot boat, correct? That's page 6. Line 91.
Yeah.
And at the same time, you were supporting your wife's niece through college, correct?
I don't know about supporting her. Apparently, we contributed to her living expenses.
Okay, you contributed to her living expenses?
Correct.
Okay. And at this same time, you had already filed this lawsuit against Mr. Deaterly, correct?
Yes.
And you were paying the attorney at that time. I know it was a different attorney than you have right now, but at that time, you were paying your then attorney money associated with this lawsuit, correct?
Yes.
And during this time, you were still engaged in your alimony modification proceeding, correct?
Yes.
And you had just lost your bid to reduce the amount of alimony payment to your ex-wife, correct?
I don't know about the time frame, but yes, I did.
And around this same time after you lost the alimony modification case, the primary case, you appealed that, did you not?
That's correct.
And didn't you pay your appellate attorney around $15,000 at this time?
That sounds about right.
And in addition to the $15,000 fee associated with the appeal, you had an additional $8,500 in costs associated with transcripts and other things associated with that court proceeding, correct?
Probably. I don't know about the specific dollar amount.
And around this time, you were providing $12,000 per month for household expenses, correct?
I believe so.
And this was for a house you did not own, correct?
That's correct.
Your wife owns that house, correct?
Yes, the title is in her name.
And at this time in 2017, a year after the incident with Zach occurred, you were not seeking mental health treatment, were you?
I don't recall the times that I did or did not.
Okay. Well, we'll get into that in a second, Mr. Jacobson. But you didn't start seeing Dr. Edlin until 2018, correct?
That's correct.
And prior to Dr. Edlin, you didn't see anybody else, did you?
Other than Dr. Marcantonio.
Correct. But the first time you mentioned any worsening depression associated with this incident wasn't until August of 2018, correct?
Probably.
At the time of the incident on November 18, 2016, you had nearly 191,000 miles on your truck at that time, correct?
I don't recall the exact mileage.
Would that be fair to say 191,000 miles?
In what year?
2016, November 18th?
Probably.
And as a result of the, well, I shouldn't say as a result, but after the incident occurred, you only experienced one flat tire, right?
That's correct.
And you allege that that flat tire was caused by Zach, correct?
That's correct.
Because you assume, to quote your earlier testimony, you assume that Zach shot the tire, correct?
Correct.
But in fact, you replaced all 4 tires just 4 days after the incident, didn't you, Mr. Jacobson?
Yes, I believe that's true.
Okay. And the only reason that you replaced all 4 tires, as you testified to in your deposition, was not because they all needed to be replaced, but because you did not want to have tires that did not match. Do you remember that?
Yes.
And in fact, you testified that with the other 3 tires, there was only moderate wear on those tires, correct?
I don't recall categorizing whether it was moderate or slight or what.
Can we play clip 44, please? What was the condition of the other 3 tires?
They had moderate wear, but they were not defective.
So, wear, and they were not defective in any way, correct?
That's correct.
In other words, you actually placed all 4 tires just so you would have all 4 of the same type of tire, correct?
Yes.
And the total cost for repairing those 4 tires or replacing those 4 tires was $1,057, correct?
That sounds right.
You testified earlier that you assume Zach shot the tire out of your truck, but just to be clear on the record, you did not see any bullet strike your tire, did you?
No.
And you don't know for sure what caused the tire to go flat, do you?
No.
The same month that you filed this lawsuit, the lawsuit was filed August 15, 2017, that same month, you went to Ireland, correct?
I don't remember the date we went to Ireland, but yes, we did go to Ireland.
Can we pull up Exhibit 7 and go to page 44, please? Can you blow up the date, please? These are your medical records from August 3rd, 2017, already been admitted in evidence. And if we can get up the subjective section for the plan. You see on that note where it states that you received a prescription for doxycycline to take with you when you go to Ireland, and that you were going in about a week or so.
Right.
So a week or so after that would have been somewhere around August 15, 2017, correct?
That seems right.
Right around the time that the complaint in this case was filed, correct?
Yes, I guess so.
A complaint that you filed alleging that you suffered from severe emotional distress, unable to do anything, unable to enjoy life, and yet you're going to Ireland, correct?
That's correct.
And in this note on August 3rd, 2017, just 12 months before you file, or 12 days before you file the lawsuit in this case, you didn't mention to the doctor, Mark Antonio, anything about the incident that we're here for today, did you?
I don't recall.
So we have the medical record right in front of you.
Right.
We can go through a couple pages. Dr. Mark Antonio made no note of you telling him about the incident.
Right.
Would that seem about right?
Yes.
After the incident, you didn't stop working, did you?
No, I worked less hours, but I did not stop.
And you still exercised, correct?
Do I still exercise now?
No, I'm asking after the incident that we're here for today.
Yes.
And you still went boating, correct?
I didn't really boat as much after the incident, immediately after the incident.
Okay, but shortly thereafter, or sometime thereafter, you went back to boating, correct?
Yes.
You were here yesterday, sitting at the plaintiff's table, correct, during the testimony of your wife?
Yes.
And do you recall your wife testifying that you had not been boating?
Yes, I remember that.
So she wasn't telling the truth, was she?
No, I wouldn't say that.
Okay. And then you heard your wife's testimony yesterday that you hadn't been fishing in years. You heard that, correct?
Correct.
But that's not true either, is it?
No, I have. No, that is true because I have not been out fishing.
Okay. Do you recall your updated deposition that I took back in April?
Not in full detail, no.
What's the name of your friend that lives in Wisconsin?
I have a number of them.
The one that you go fishing with?
Roger Stanek.
Roger Stanek. Didn't you testify during your updated deposition that after the incident you had gone fishing with Roger Stanek?
I don't recall saying that, but it probably was true.
Probably was true.
Yes.
Do I need to get your updated deposition and go through it with you?
Objection argumentative.
Did you also testify that you had gone fishing with Roger Stanek in the last year?
He doesn't. He lives in Wisconsin. They spend time here in the winter months. So I'm not sure what time frame we were talking about.
Okay, so today is June.
Mm-hmm.
So in the winter of 2020 to 2021, did you go fishing with Mr. Stanek?
No, I don't believe so.
Okay. Go ahead and turn to page 210 of your deposition. Beginning at line 24. Question. Do you
I
and
haven't
Roger...
gotten to 210 yet.
Oh, I'm sorry.
Okay.
Beginning on line 24. Okay, how often do you and Roger go fishing while he's in town? Answer, when he's here, probably out of the 4 months, we probably go 6 or 8 times. Did I read that correctly?
Which lines are we talking about?
Beginning on page 210, line 24. Question. Okay. How often do you and Roger go fishing while he's in town? Beginning on page 11, line 1. Answer. When he's here, probably out of the 4 months, we probably go 6 or 8 times. Did I read that correctly?
Correct.
And when you would go out with Mr. Stanek on fishing trips, how long did the fishing trips usually last for, Mr. Jacobson?
Probably just a half a day or a day.
Okay. So when you would go fishing with him, it would be a day, correct? Or a half a day to a day, right?
Right.
And when you would go fishing with Mr. Stanek, would you carry on conversations with him about the dog Candy and Candy's death?
Objection, calls for hearsay.
I can't recall if I did or not.
If you begin on page 211, line 16, question. Okay, and out of those day trips fishing, how often do you discuss the distress or your trauma associated with the incident between Candy and Mr. Deaterly? Answer, well, it's brought up whenever we're together, depending on what we're doing. It doesn't, it may be 10 minutes of explaining how I'm not feeling well, but it's not a specific sit down time, no. So after the incident occurred, you still went fishing with your friend Roger Stanek, correct?
Yeah.
And that would include recent trips fishing with Roger Stanek during the winter time or winter months that he would be down here in Florida, correct?
We haven't done it for a couple of years now, because they've been staying in a different area.
Go ahead and turn to page 212 of your deposition, Mr. Jacobson. If I understand your testimony correctly, you said it's been a couple of years since you went fishing. If you look at line 20, question, when's the last time you went on a fishing trip with Mr. Stanek? Answer, it would have been, they returned in, would have been March of this spring, 2022. Did I read that correctly?
Yeah, I'm not clear how you're concluding that it was of this year.
Well, let me read it again. 212, you're there, correct? Page 212?
Yes.
Line 20, let me know when you're there.
Yes.
Oh, and let me preface this by asking you a couple questions. You were deposed on April 27, 2022, correct?
Yes.
That was 2 months ago, correct?
Yes.
Page 212, line 20. When's the last time you went fishing on a fishing trip with Mr. Stanek? Answer, it would have been, they returned in, would have been March of this spring, meaning 2022, correct, Mr. Jacobson?
Seemingly, yes.
Oh, it's your testimony, is it not, Mr. Jacobson?
Yes.
So despite your wife testifying yesterday that you had not been fishing in years, she wasn't telling the truth, because in fact you had been fishing in years, correct?
Yes.
Now, you testified earlier during your testimony that your wife was committing adultery on you with another woman. You remember testifying to that?
Yes.
Your first wife, not your current one, your first
Correct.
wife. Which caused you depression, did it not?
Yeah, it probably did.
I mean, after that occurred, did you not go seek the care of a professional, healthcare professional?
Yes,
You sat down with either a psychologist or psychiatrist, correct?
psychologist.
And not only did you seek treatment after that occurred, but you started taking the prescription Zoloft, correct?
That's correct.
And you never stopped taking Zoloft between the time of the incident involving your ex-wife and the incident with Mr. Deaterly, did you?
No, I don't believe so. I
But
don't
you-
believe that I did continue to take Zoloft during that period.
You did continue to take Zoloft during
Yes.
that period. Do you recall testifying during your deposition that you had weaned yourself off of Zoloft about a year after the incident involving your ex-wife?
I don't recall that.
Can we play clip 48, please? That's the wrong clip. I'm sorry. I meant clip 49.
Yeah, I was on Zoloft.
How long were you on Zoloft for?
Probably, I only saw it 2 times, but it's probably a year after that. And then I saw my
That's you in your testimony, correct, Mr. Jacobson?
Correct.
But despite testifying during your deposition that you had weaned yourself off Zoloft, you had continuously taken it for 20 years, correct?
Yes, I believe so.
And at the time of your initial deposition in January of 2018, you had not seen any mental health professional, correct? For your alleged depression associated with the incident involving Mr. Deaterly.
I don't believe so.
Who was your primary care physician at that time, around November of 2016? Can we pull up exhibit? These are records that are in evidence. These are Dr. Marcantonio's records for your patient care, Mr. Jacobson. The very first record that I have is dated April 19, 2016. Do you see that? And for that visit, you were there for a 5-month follow-up, correct? And this visit was prior to the incident in this case, correct? We can turn to the next date. The next time you visited with Dr. Marcantonio, and that'll be bait stamp page number 7. Was May 24th, 2016, correct? And on May 24th, 2016, you came in for a cough and congestion that you'd had for about 2 weeks or so, correct? And this was before the incident in this case occurred, correct? Let's turn to bait page stamp 13. The next time you visited with Dr. Marcantonio after that visit was November 22nd, 2016, correct? And this was 4 days after the incident in this case occurred, correct? And you were there on November 22nd, 2016 for a wellness exam, correct? And you, in preparation for that visit, you completed an annual wellness exam form? On November 22nd, 2016, you didn't mention the incident that occurred 4 days prior to Dr. Marcantonio, did you? Let's go ahead and pull up exhibit number 10, please. This has been admitted into evidence as Exhibit 10, Joint Exhibit 10. This is your 2016 Medicare Wellness Exam form dated November 22nd, 2016. Is that your handwriting, Mr. Jacobson?
Some of it is, yes.
Okay. Are the check marks in the answers in response to the questions your check marks?
No, I don't know who made those check marks.
You don't know who filled them out? Let me ask you a question. When you met with Dr. Marcantonio on November 22nd, 2016, he reviewed this annual wellness exam form with you, correct? And in doing so, you gave him the answers to the questions in this form if you hadn't already filled it out, correct?
I believe it had already been filled out.
Okay. But nevertheless, you went over this form with Dr. Marcantonio during your visit on November 22nd, 2016, correct?
I can't say for sure.
Well, let's turn back to Exhibit 7, bait stamp page number 13. Do you see in Dr. Marcantonio's notes where he states he brings in his wellness forms, which were reviewed in detail, page by page? They will all be scanned into the EHR, correct?
Yes.
Now, in reviewing the annual wellness exam form found at Exhibit 10, in reviewing that with Dr. Marcantonio, if something wasn't true, you would have corrected Dr. Marcantonio about that, correct?
Probably.
On November 22nd, 2016, in response to the question, over the past 2 weeks, how often have you felt down, depressed, or hopeless? What was your response? And that's Exhibit 10. So I'll re-ask the question now that it is in front of you. Over the past 2 weeks, how often have you felt down, depressed, or hopeless? What was your response?
Almost
Over the past 2 weeks, how often have you felt little interest or pleasure in doing things? What was your response?
almost.
To the question, have your feelings caused you distress or interfered with your ability to interact socially with friends? What was your response? To the question, during the past 6 months, how often have you felt sad or depressed? What was your response? To the question, in general, how satisfied are you with your life? What was your response? To the question, how often is stress a problem for you? What was your response? To the question, how well do you handle the stress in your life? What was your response?
Usually able to cope with it.
To the question, how often do you get the social and emotional support you need? What was your response? Can we scroll up a little bit, please? Can you see it now, Mr. Jacobson? Let's go ahead and turn back to Exhibit 7. And we'll go to bait stamp page 19. your first visit with Dr. Mark Antonio after November 22nd, 2016.
Where are we at now?
It's right there in front of you, Mr. Jacobson, not in your deposition. We're looking at exhibits that are on your
Oh,
screen.
on the screen.
If it's easier for you, Mr. Jacobson, if I may approach, Your Honor. So I'm at bait stamp page 19.
Okay.
And this is May 1st, 2017, correct? And on May 1st, 2017, you presented with a complaint that you had right shoulder pain and bradycardia, correct?
That's correct.
And during this visit on May 1st, 2017, you made no mention of the incident involving your dog and Zach, did you?
Apparently not.
If you can turn to bait stamp page 25. Your next visit after May 1st, 2017 occurred on May 23rd, 2017, correct? And this was for a 6-month follow-up, correct?
Yes.
And under history of present illness, Dr. Mark Antonio stated in general that you were doing fairly well, correct?
That's concluded, yes.
And on May 23rd, 2017, you made no mention about the incident involving your dog and Zach, did you? Let's go ahead and turn to bait stamp page number 31. These are records from July 5th, 2017, which would have been your next visit, correct?
Yes.
And you presented to Dr. Mark Antonio with a deep cough, correct? Dr. Mark Antonio mentioned that you had had a congested cough for the last week and a half to 2 weeks, correct?
Yes.
And during the visit on July 5th, 2017, you made no mention about the incident involving your dog and Zach, did you?
Apparently not.
If you can turn to bait stamp page 36. Your next visit with Dr. Mark Antonio occurred on July 11, 2017, correct?
Yes.
And you presented to Dr. Mark Antonio for a persistent cough, correct?
Right.
You presented to him because of a worsening cough and congestion, correct?
Yes.
And on July 11, 2017, you made no mention about the incident between your dog and Zach, correct?
That's correct.
Go ahead and turn to bait stamp page 41. This is your medical record dated August 3rd, 2017, which would have been your next visit with Dr. Mark Antonio, correct? And again, you presented with Dr. Mark Antonio for cough and congestion, correct? You had stated to Dr. Mark Antonio that you came in because of some cough and congestion and that you thought you were getting more post-nasal drip and drainage, correct? And on August 3rd, 2017, that's the same mention on bait stamp page 44 that you would be going to Ireland. Can you turn to bait stamp page number 46? Your next visit with Dr. Marcantonio after you returned from your trip from Ireland was November 29, 2017, correct?
Yes.
And you went to see Dr. Marcantonio on November 29, 2017 for a wellness exam, correct?
Correct.
Do you see where he notates that you brought in your wellness forms, which are reviewed in detail? Do you recall completing a 2017 annual wellness exam form for Dr. Marcantonio?
No, I don't.
We can bring up Exhibit 11, please. And you can also look at it in the book that you have in front of you, Mr. Jacobson. Please let me know when you get there. This is what's been admitted as Exhibit number 11, Joint Exhibit 11. This is a annual Medicare Wellness Exam form dated November 29, 2017. Do you see that?
Yes.
And is this your handwriting under patient's name and date of birth?
Yes.
And did you complete this form?
I don't recall.
But nevertheless, you went over this form with Dr. Marcantonio during that visit on November 29, 2017, correct? In response to the question, over the past 2 weeks, how often have you felt down, depressed, or hopeless? What was your response? To the question, over the past 2 weeks, how often have you felt little interest or pleasure in doing things? What was your response? In response to the question, have your feelings caused you distress or interfered with your ability to interact socially with friends? What was your response?
No.
In response to the question, during the past 6 months, how often have you felt sad or depressed? What was your response?
Almost never.
And this was a year after the incident involving your dog and Zach, correct? In response to the question, in general, how satisfied are you with your life? How did you respond?
Satisfied.
In response to the question, how often is stress a problem for you? What was your response?
Sometimes.
In response to the question, how well do you handle the stress in your life? What was your response?
I'm usually able to cope effectively.
So we're going to switch back to exhibit number 7, Mr. Jacobson, at date stamp page 46. These are your records from November 29, 2017, which is the annual wellness exam that the form we just went over. And that was the visit. During this visit, you didn't mention anything to Dr. Marcantonio about the incident involving your dog and Zach, did you?
Apparently not.
Next, we'll turn to bait stamp page 52. The next time you saw Dr. Marcantonio after November 29, 2017 was February 27, 2018, correct?
Apparently.
And you presented with a complaint about your right lower arm being red from removing a sliver yesterday. Do you see that?
Yes.
And you had presented or came in for a visit with some redness in your right forearm, correct? On February 27, 2018, you mentioned nothing to Dr. Marcantonio about the incident between your dog and Zach, did you?
Apparently not.
Go ahead and turn to bait stamp page 57. The next time after that visit that you saw Dr. Marcantonio was May 31st, 2018, correct? and you presented to Dr. Marcantonio for a scratch on the left side of your face from a tree branch, correct?
Yes.
And on May 31st, 2018, you didn't mention anything to Dr. Marcantonio about the incident between your dog and Zach, did you?
Really not.
Can we turn to bait stamp page 061? Your next visit with Dr. Marcantonio occurred on June 5th, 2018, correct?
Yes.
And you presented to Dr. Marcantonio for a 1-week follow-up for the scratch on the left side of your face, correct? And during this visit with Dr. Marcantonio on June 5th, 2018, you mentioned nothing about the incident between your dog and Zach, did you?
No, really not.
And then we can turn to bait stamp page 065. This is a record from Dr. Marcantonio dated August 15, 2018, correct? The chief complaint, per wife, you weren't feeling yourself, correct? You came in for a visit because you were not feeling yourself, correct?
Yes.
Did your wife accompany you to this visit?
I don't believe so.
Do you see where it states that patient's wife concerned and has confirmed his depression?
Yes.
And then do you see where you presented with increasing issues about seeing your dog being shot? And then also more stress secondary to your prior divorce issues. Do you see that notated in the records?
Yes.
So on August 15, 2018, which was almost 7 months after your deposition occurred in this case, and nearly 2 years after the incident in this case occurred, is the first time you presented to any medical professional about a worsening of your depression associated with this incident, correct?
Yes.
And 2 days prior to that visit with Dr. Marcantonio, weren't you told and informed that we would be subpoenaing your medical records through this case?
I don't recall that.
Is there anything that would refresh your recollection of that?
I'm not sure.
Your Honor, if we may approach.
So, what we just had a meeting on was, got to give some context to this. In the course of litigation, there's various devices that are used to get information from one side or the other. One of these devices is depositions. Another one is something we call a notice of a production from a non-party. So when somebody who's not associated with the lawsuit has documents or material that one party needs, there's a document that's called a notice of production to the non-party that goes out to say, hey, so-and-so, whoever the person is, we want to get some of your records. We know you're not a party to this case, but we're asking for you to produce them anyway. And that was done in this case on August 13th of 2018. The defendant filed a notice of production to a non-party, namely Dr. Marcantano, saying, doctor, please provide me your medical records. Okay, so that's what the request was. It was a notice of production to Dr. Marcantano asking for the medical records of the plaintiff. Okay. Is that okay? The panic agrees. All right, go ahead.
Your Honor, I think you need to switch on, since we had to disconnect that.
What do you need on?
I think we need to, yeah. I'll go ahead and I'll show you what will be marked as Defense Exhibit A. And this is the notice of production from non-party directed to Dr. Marcantonio. And on the second page is the date of August 13, 2018. You recall that, Mr. Jacobson?
No, I do not.
Okay. And can you scroll 2 more pages over? Or excuse me, go back 1 more. And can you go into the document requested section? Were you aware on August 13th, 2018 that I had issued a notice that I intended to subpoena your medical records from Dr. Marcantonio pertaining to any mental health or psychological or psychiatric issues for you? Okay. I guess at this time, Your Honor, I would move that Defense Exhibit A be admitted into evidence. I believe you're taking judicial notice of.
Any objection?
No, Your Honor.
Madam Clerk, we'll print you a hard copy. I just don't have it. You can take it down. We can pull back up exhibit number 7. And this is the Dr. Marcantonio's notes from August 15th, 2018. And Dr. Marcantonio referred you to see a psychiatrist, correct?
Yes.
And that psychiatrist that he referred you to was Dr. Matthew Edlund, correct? And Dr. Edlund, you only saw a total of 5 times, correct?
Probably, yes.
Do you remember filling out supplemental interrogatories, answers to supplemental interrogatories in this case a couple months ago?
Not all the specifics.
Okay, but I think your wife testified yesterday that you gave her the answers and she typed it up for you, correct?
I believe so.
Okay. Can we pull up exhibit number 27, please? We'll highlight the answer to question number 3. In your answers to interrogatories, you stated that you had sought treatment with Dr. Edlund approximately 10 to 12 times, correct?
Yes.
But in fact, it had only been 5, correct?
Yes.
You can take it down. And during your treatment with Dr. Edlund, he did not prescribe you any medication, did he?
Not that I recall.
Can you play clip 51, please? You testified during your deposition that he did not prescribe any medication to you, correct? So the entire time that you were treating with Dr. Edlin, Dr. Marcantonio was the only one that was prescribing Zoloft to you, correct? And you never had any out-of-pocket expenses associated with the treatment that you received from Dr. Edlin, correct? And when Dr. Edlin stopped taking Medicare, that is when you stopped seeing him, correct?
That's correct.
So the 5 treatment sessions you went to for the alleged emotional distress you suffered as a result of the incident between Zach and your dog, you paid absolutely nothing for, correct?
As far as my recollection,
In addition to Dr. Edlin stopping taking Medicare, you also stopped seeing Dr. Edlin because you said that the cost of $210 for a 30-minute session was too high, correct? And your last visit with Dr. Edlin was on May 29, 2019, correct? And at the time of your last visit with Dr. Edlin, there was quite a bit happening in your alimony modification case, correct?
yeah, I guess so.
And just so it's clear for the jury, my questioning you regarding this is gonna fall into 2 separate categories, okay? In January of 2021, you suffered a severe fall and fractured your skull, correct? And after you fell and fractured your skull, you sought to abate your alimony, correct? So we'll refer to that as the abatement action, okay? So when I say or refer to the abatement action, that's what I'm referring to, okay? When I say anything about the alimony modification proceeding, that would have been the proceedings involved in your divorce prior to your January 2021 accident, okay? So, sorry. Okay, that's fine, Your Honor.
Dr. Morris, Your Honor. 4 p.m. to testify. So, Your Honor, Zoom.
tea, 4 o'clock.
Thank you, Your Honor.
Ms. Jacobson, you could retake the stand.
Your exonerate.
Okay, we have the jury reseated and the parties are present. I just want to add something to the juror question about the depositions. You can have a seat. The reason we don't allow depositions to be in evidence is that there's a far-ranging examination that's done in depositions. And whatever comes into the courtroom has to pass the test. This is the evidence code of the state of Florida. I've got to decide what evidence is admissible based on the legislature's guidance. To a large extent, a lot of that doesn't apply in depositions, so there's a lot of extraneous, irrelevant material, maybe prejudicial. So we don't allow depositions in. We allow excerpts of it where it's pertinent, but we don't allow the whole thing. All right, go ahead.
Thank you, Your Honor. Mr. Jacobson, before we broke, I'd asked you the question that at the time of your last visit with Dr. Edlin on May 29, 2019, that there was quite a bit happening in the alimony modification proceeding. Is that correct?
Seemingly that did overlap.
Excuse me?
Seemingly that did overlap, yes.
Okay. And just to give I know you testified about it earlier that you had paid your ex-wife over $1 million of alimony during the time that you paid alimony, but I just want to be able to provide a little more context associated with that to the jury. You were originally obligated to pay your wife $5,000 per month, correct? And I apologize, your ex-wife $5,000 per month, correct?
Actually, the initial was $4,500. It stated $4,500.
It was $4,500 and it stayed at $4,500?
Yes,
Okay. And then you sought to reduce that payment through the alimony modification proceeding, correct?
Correct.
And you lost that case, correct? And after losing that case, you appealed, correct?
Correct.
And in the alimony modification case, you were asking to essentially eliminate your alimony altogether, correct?
I was trying to demonstrate a supportive relationship between her and her partner.
Okay. And you were asking the court to eliminate the alimony altogether, correct?
Correct.
And in seeking the modification of your alimony, you paid in excess of $600,000 to include your attorney's fees and your ex-wife's attorney's fees, correct?
Yeah, that sounds right.
And on May 19, 2019, then Judge Padar Berlin, who's now Judge Padar, entered an order requiring you to pay your ex-wife's attorney's fees in the amount of $67,237.50 and costs of $9,292.50 for a total of $76,530, correct?
Yes.
And this was 10 days prior to your last visit with Dr. Edlin, correct?
I don't recall the actual dates.
Okay, the last. And on May 23rd, 2019, Judge Bonner entered an order requiring you to pay $25,265 to your ex-wife for fees that she incurred in the appeal of the alimony modification case, correct?
Yes.
And at the time of the May 23rd, 2019 order by Judge Bonner, did your last tax return reveal gross income from your business in the amount of $9,932,266?
Yes, but that was an incorrect number.
And ordinary business income to yourself of $1,768,948, correct?
I don't think that was accurate.
Can we pull up Exhibit 25, please? And we're going to go to page 3. And if we can highlight paragraph 19. This is the order signed by Judge Bonner on May 23rd, 2019. This is an excerpt where the court noted that your last tax return provided revealed an annual gross income of $9,932,366. Do you see that?
Yeah.
And ordinary business income to yourself of $1,768,948, correct? Okay. And you dispute what the court found in the court order? Okay. And around the same time that you stopped seeking treatment with Dr. Edlin, you had purchased a yacht for $565,000, correct?
Yes, I believe that was the
Okay.
number.
And you purchased it with a loan of $324,000, correct?
That sounds right.
And the yacht had equity of $225,000, correct?
Yes, that's the arithmetic is correct.
And at that time, in May of 2019, when you stopped seeking treatment with Dr. Edlund, you had already spent in excess of $100,000 on this case that we're here for today, correct?
That I can't testify to because I don't have any knowledge from the previous law firm with me or have full knowledge.
If we can go to paragraph.
It sounds right.
It sounds right. If we can go to paragraph 21 of that order. Do you see where the court noted that you had spent over $100,000 in attorney's fees in an unrelated civil lawsuit of which you were the plaintiff?
Yes, I see that.
And that would be this case here that we're here for today, correct? And that was in May of 2019, correct? We can take it down. Despite being ordered to pay your ex-wife alimony payments, you didn't initially pay those amounts to your ex-wife, did you?
Okay, which amount?
The amounts under the orders that we just went over. The order dated May 19, 2019 from Judge Padar, ordering you to pay $76,530, and the order dated May 23, 2019, ordering you to pay $25,265 to your ex-wife.
All of that was eventually paid.
I understand that, but you didn't initially make the payments as required under that order, did you?
No.
And on September 12, 2019, you were held in contempt of court for failing to pay the appellate fees ordered by Judge Bonner, correct?
I believe that was the scenario, yes.
If we can pull up Exhibit 21, please. Go to the first page. Under the contempt order dated September 12, 2019, did the court determine that you had the ability to pay the amount of $25,265?
Yes.
And in making this determination, the court ordered you to make a payment of 1/2 of the amount owed by noon that same day, or else you would have been imprisoned, correct?
Yes, that's what it said.
And then the court ordered you to pay the other half within 15 days thereafter, correct?
Yes.
Otherwise, if you didn't pay it, you would have been taken to jail, correct?
That's what the order says.
And prior to September 12, 2019, you made no effort to make payments to your ex-wife pursuant to the court order dated May 23rd, 2019, did you?
I don't recall not paying.
Do you recall bringing a checkbook or any other means of payment with you to the hearing on September 12, 2019?
No.
meaning you did not bring it or you don't recall? You did not bring a checkbook or any other means of payment, correct?
Correct.
And you were aware of the hearing that you were going to be held in contempt if you failed to pay, correct? Did the threat of imprisonment for failing to abide by a court order cause you stress on September 12, 2019?
Yes, to some extent.
And then on October 8, 2019, you entered into an agreement with your ex-wife regarding payment to your ex-wife pursuant to Judge Padar's order, correct? And you agreed to make payments to your ex-wife in accordance with that agreement, correct?
Yes.
And despite that agreement to do so, you didn't fully pay your ex-wife, causing you to be held in contempt of court again on July 14, 2020, correct?
I'm not familiar with the date.
Can we pull up Exhibit 23, please? And let me know when you're there, Mr. Jacobson. Under Exhibit 23, the court notated the $70,090 that you were ordered to pay under the order signed by Judge Padar on May 23rd, 2019, correct?
Yes.
And then the order notates that you again failed, that you entered into an agreement to pay those amounts, correct?
That's correct.
And that at that point, when you were held in contempt on July 8, 2020, that you had still failed to pay the balance of $49,590, correct?
That's what the order says.
And the order found that you had an ability to pay those amounts, correct?
Yes.
Did being held in contempt of court and being required to make these substantial payments to your ex-wife cause you any stress?
To some extent, really caused me anger more than anything.
And despite these two court orders that were entered by the court, by Judge Padar and Judge Bonner, requiring you to pay your ex-wife's attorney's fees associated with the alimony modification and the appeal of that, you were still nevertheless required to pay your ex-wife monthly alimony payments in addition to that, correct?
Right.
And you failed to do so, correct?
I don't recall failing to do so.
Okay. Weren't you again found in contempt of court on January 10th, 2022 for failing to pay alimony to your ex-wife?
That may be the right time frame.
Okay. But you remember that, right?
Yeah.
And again, on January 10th, 2022, the court had determined that you had an ability to pay alimony to your ex-wife, didn't it?
Yes.
However, recently, you entered into a stipulation with your ex-wife where you would pay her $100,000 and you would no longer have to worry about paying her alimony again. Is that not correct?
That's true.
Safe to say that you're now completely done with your ex-wife?
Yes.
And you had paid her in excess, I believe you testified earlier today, in excess of $1 million total in alimony payments, correct?
Correct.
In getting rid of your ex-wife and those alimony obligations, you felt a sense of relief, didn't you?
To some extent, yes.
In December of 2019, you were sued by American Express, correct?
The company was.
Excuse me?
My company was.
Oh, you're the sole owner of the company, right, Mr.
Correct.
Jacobson?
Correct.
Without you, there's no company, correct?
That's correct.
Okay. So in December 2019, you and your company were sued by American Express, correct?
Correct.
And were you sued for failing to pay a line of credit with American Express?
Yes.
And the amount that you owed to American Express was close to $100,000, correct?
Close to what? $100,000?
Close to $100,000.
Yes.
and you ultimately settled with American Express, agreeing to make an initial payment of $16,246.99 and subsequent monthly payments of $5,000 until the balance was paid off, correct?
Correct.
Did having to make these payments cause you stress?
No, I was obligated to do it.
How much money have you spent in total on this litigation, Mr. Jacobson?
Objection, Your Honor. Attorney-client privilege.
That's not attorney-client privilege.
Hold on. Don't debate it. Come up here. Oh, come back. I just. There's asked a question about whether the police checked the gun to see how many shots were fired, caliber of the gun, and whether it revolver or magazine. I think we've had testimony that it was a revolver,
Yes, Your
so
Honor.
that's not in dispute. And I think the answer to this may be coming in later testimony, so we'll just wait and hold that thought, and we'll see if it goes there or not. It may come into evidence.
And Your Honor, for the record, this objection was sustained
After you stopped treating with Dr. Edelin, you spoke to Dr. Marcantonio about finding another provider, correct?
That's correct.
And Dr. Marcantonio referred you to MedPsych Services, which took Medicare payments, correct?
I believe so.
And you did not seek any treatment from any providers at MedPsych Services, did you?
I did not.
And other than the referral by Dr. Marcantonio, you made no other efforts to try and seek treatment for the emotional distress following your treatment with Dr. Edelin, did you?
I did not.
You didn't make any effort to find a more reasonably priced provider or one that accepted Medicare, did you?
No, I did not.
And you didn't apply for any reduced therapy based on low income or seek any other type of financial assistance, did you?
No.
And after your last visit with Dr. Edelin in May of 2019, you haven't received any kind of treatment for your emotional distress that you attribute between the incident between your dog and Zach, have you?
No.
You don't attend any support groups, correct?
No.
You don't attend any therapy groups, correct?
No.
In January of 2021, you were involved in an accident where you fell from scaffolding, correct?
Yes.
You fractured your skull, correct?
Correct.
Pretty serious injuries, correct?
Yes.
At any point in time from November 18, 2016, up until your accident in January of 2021, did you ever stop taking Zoloft?
Yes, I think I did.
Do you recall testifying in your updated deposition back in April of this year that you did not ever stop taking Zoloft during that time period?
Then I would rely on that.
On your testimony from 2 months ago?
Yeah.
Would you like to see that testimony?
No.
Okay. From the time of the incident in this case, November 18, 2016, to the time of your accident in January of 2021, there were no activities you no longer participated in because of your alleged emotional distress, correct?
I don't understand the question.
Let me go ahead and read it to you again. From the time of the incident in this case, November 18, 2016, up until the time of your accident in January of 2021, there were no activities that you no longer participated in because of your alleged emotional distress as a result of this incident, was there?
No, but I did, because of my head injury, I did not go back to riding my bicycle.
Sure, and the question focused November 18, 2016 and January of 2021. So it would have been before your head injury in January of 2021.
Right.
Okay. And during that time frame, there were no activities that you engaged in prior to that time that you didn't engage in during that time period, correct?
Well, other than being able to spend time with Candy, who was gone during that period of time.
Okay. And you didn't stop going on your boat anymore, correct?
I limited my boating by quite a bit.
Do you recall testifying during your deposition that you didn't stop going to your boat? Didn't stop going on your boat anymore in April of 2022?
Well, I think I reduced my time I spent on it.
Okay. And again, you heard your wife testify yesterday that you have not and don't use your boat, correct? And that's not true, is it? Because you still use your boat, right?
But sparingly, so I'm not sure her response was not true.
And from the time of the incident in this case, so November 18, 2016, and your accident in January of 2021, you didn't work any less, did you?
Yes, I did work somewhat less.
Do you recall testifying during your deposition 2 months ago that during that time frame you didn't work any less?
I don't recall that.
Can we play clip 64, please? From 2018,
Immediately after the incident
back into that 2018, 2021 so prior to your fall. Okay. So my question to you is during that 3-year time frame, did you work the same amount of time during that 3-year time frame?
Yeah.
And after your accident in January of 2021, you only stopped working for a little while, correct?
Probably, yes.
Do you recall your wife? Well, let me ask you this. For how long did you stop working for after your accident in January of 2021, Mr. Jacobson?
A number of months.
How many?
Well, I didn't drive for almost a year, so it probably would be 8 or 10 months.
Did you listen to your wife's testimony yesterday where she testified that you didn't work or drive for 14 months?
Yes, I guess I do remember her saying that.
And that's not correct, is it?
No, her timekeeping may be better than mine.
Do you recall testifying during your deposition in April of 2022 that you only stopped driving for about 4 or 5 months after your January 2021 accident?
I don't recall that.
Can you play clip 65, please? Now, do you recall testifying that it was 4 or 5 months during your deposition in April 2022?
Yeah.
And after your accident in January of 2021, you only stopped working for a little while, but returned to work not too long thereafter, correct?
But not full time.
Not full time? But you still went back to work, correct?
Correct.
And you currently drive, correct?
Yeah.
Did this accident that you sustained in January 2021 cause you to experience any depression?
I would say no.
You no longer take Zoloft, correct?
I no longer take Zoloft. Correct.
You take actually 2 different antidepressant medications now, correct? And you only started taking those 2 medications after you started seeing Dr. Cantero after your fall in January of 2021, correct?
That's correct.
And he prescribed those to you as a result of your worsening depression as a result of that fall, correct? Do you know who Richard Reith is?
Yes.
Who's Richard Reith?
He was I think he's a PhD that was hired by my wife and her attorney to evaluate my condition.
And that was for the alimony abatement proceeding, correct? And in that proceeding, you were attempting to try to not have to pay alimony at all until your condition got better, correct? Do you recall him testifying for you during one of your alimony abatement proceedings? And that was during one of the contempt of court proceedings, correct?
I don't know if this was part of it. I don't know if it was part of that or not.
Okay. And that was, you had a visit with him in December of 2021, correct?
Yeah.
I heard you testify earlier today that you routinely cry over the incident, cry over candy, correct?
Yes.
Then when I deposed you in April of 2022, isn't it true that you couldn't remember the last time that you cried over losing Candy, correct? Can we play clip 71, please? You cry as a result of the emotional distress you suffer from the incident you witnessed between Candy and Mr. Deaterly. I have. Okay, when's the last time you cried? That was your testimony, correct?
Right.
And when you did cry over Candy, it wasn't for any length of time, was it?
What do you mean by any length of time?
It wasn't.
While I was tearful, you mean?
Correct.
Well, it was a substantial amount. I mean, I tend to be not very emotional about things, but I certainly was with that.
So I'll ask you the question again. And when you did cry, it wasn't for any length of time, correct?
I guess I don't know what you mean by length of time. That's pretty subjective.
Okay. What's the length of time to you? Well, let me ask you this. How long do you cry? When you cry about Candy, the last time you cried, you couldn't remember when that occurred. But when it does occur, how often or how long does it last for? How long do you cry?
5 or 8 minutes.
And I know that in April of 2022, you couldn't recall the last time that you cried over Candy. As you sit here today, do you remember the last time you cried over Candy?
Yes.
When was it?
Just a couple days ago.
Okay. And how long did you cry for?
Probably 5 minutes or so. And I was by myself driving.
Did you ever say or testify that if D had owned the property where the incident occurred, that you wouldn't have sued him?
Objection again, Your Honor. Calls for speculation. Same question from earlier.
It is not the same question from earlier, Your Honor. I'm asking him if he ever said that he wouldn't do that.
Thank you.
When you had the truck parked at the Luella Lane property, it was backed in, correct? Which would mean that the tailgate was facing the Roberts Bay, correct? Facing where the dock was.
Correct.
And the front was facing outwards towards the entrance of the property, correct?
That's correct.
And you had testified earlier that the surgery on Candy was not successful. You recall testifying about that?
Yeah.
But that's not entirely correct, is it?
Well, it wasn't. They didn't manage to save her life.
But they didn't manage to save her life because you wanted them to stop CPR on your dog when she was in post-operative recovery, correct?
Yes, she had arrested on 2 occasions, and they asked if they wanted me to have them resuscitate her if she arrested again, and I did not want her subjected to that. So
Okay. May I have a minute, Your Honor?
Yes.
No further questions.
No redirect, Your Honor.
Mr. Jacobson, you can step down.
Okay. Thank you.
I think our next witness may be appearing by Zoom, so I need to make sure we have our IT folks here to set it up so we can let the jury relax for a few minutes. Yes. It's difficult to hear some of the clips. So I think, can you boost the volume? The ones that we were playing.
It's not through our end, Your Honor. We have the volume turned up all the way.
I've got courtroom volume almost up. I'll ask IT to come in and work their magic.
Okay.
Okay, thanks. Let's take 15.
Exiting, all rise. Court's in a brief recess.
Commissioner, you don't have any problem hearing the clips?
Some of them were soft, but I was trying to increase the volume. Dr. Tracy Morris.
Okay, Dr. Morris, I'm Judge Hayworth. I don't know if you can see me or not. Okay.
I can.
All right. So we're going to bring the jury in just a moment. Just stand by. We'll have the questioning. I understand, Mr. Kessler, you may be putting some documents on.
We will, Your Honor. Ms. Johnson will actually be handling the cross of Dr. Morris, Your Honor, but I'll be handling the presentation of the document.
All right, so I'm going to do share screen. You need that?
No. We've already got it taken care of, Your Honor.
Oh, okay. All right.
Yep.
Don't need that then. So what I want you to do is notify the jury. We may go past 5 so they can contact their family and tell them that it's possible that we may be here a little late, but not too late. And then you can bring them in after they make their calls. All right, folks, be seated. So we have next witness appearing remotely. We have a video conference line set up, and Mr. Timpanic, your witness is, please identify your witness as Tracy Morris.
Yes, Your Honor, Dr. Tracy Morris.
Dr. Morris, would you raise your right hand? Do you swear or affirm testimony you'll give today will be the truth?
Yes, I do.
All right, you'll be questioned first by Mr. Timpanic and then by Ms. Johnson. Go ahead, sir.
Good afternoon, Doctor. Could you please introduce yourself and spell your last name for the record?
Yes. Hi, my name is Dr. Tracy Morris. My last name is spelled Morris.
And what is your current occupation?
I'm a veterinarian.
And where do you currently work?
I have my own practice located in Dunedin, Florida. It's called Coastal Veterinary Care.
And were you working at that business on November the 18th, 2016?
No,
And where were you working on November 18th, 2016?
I don't know the exact date, but I believe it would have been Blue Pearl Veterinary Partners located in Tampa, Florida.
Okay. And what is your highest level of education?
My Doctor of Veterinary Medicine degree.
And where did you get your apologies. Where did you get your undergraduate degree in, and where did you get it?
My undergraduate degree was in biology pre-med, and it was from Florida Atlantic University.
And are you familiar with Candy the dog?
Yes.
And can you tell the jury how are you familiar with Candy the dog?
Candy, the dog, presented as an emergency transfer in the evening to Blue Pearl, Tampa, and I was working as an ER clinician that evening.
Okay. And what did she present with on the day in question?
Being shot and as a transfer from another ER, specifically to be taken to surgery by one of our surgeons on call.
Okay, and I'm going to see, this is always the dicey part. I'm going to try to share my screen.
Matt, would it be easier for me to do that?
Yes, please.
Okay. Just bear with me for a second while I get it set up.
Appreciate that. And are you familiar with Candy's medical records? Oh, lost.
I mean, yes, I haven't seen them in many years. So.
I previously, okay. I previously sent them to you in an email. Do you think you could
Okay.
pull them up and see if you could share your screen with us?
I can try. Do you know what email address you sent them to?
Yes. Yeah. The info one I sent earlier.
Okay, let me take a peek. Oh, are there attachments on there?
Yes.
Okay, hold on. Yep, I see them now.
Let's see if this works.
Okay.
Reviewing those medical records, are you able to tell us today what the presenting complaint was for Candy the dog, all the details?
It was a transfer from another ER, Sarasota ER, for further evaluation of gunshot wounds.
Okay, and can you tell the jury what the radiograph showed?
The radiograph showed a fractured left ninth rib, right-sided pleural effusion, patchy lung infiltrates, loss of serosal detail in the abdomen, and a metallic, ballistic foreign body in the mid-left abdomen.
And what did the physical examination of Candy the dog show?
She was recumbent and minimally responsive, vocalizing in pain. She was tachypnic. Do you need me to explain what the words mean or just read them?
Please.
Okay. She was tachypnic, which means fast breathing. She was tachycardic, which means fast heart rate. Hypotensive.
Oh, hold on. Dr. Morris, we have a court reporter. And he's,
okay.
He's pretty good, but he needs your help slowing down on the medical terms, all right?
Okay.
All right,
So she was recumbent, which means just laying there, minimally responsive. Usually like when a pet responds, so we usually comment if they're responsive or unresponsive. Vocalizing in pain when moved. Tachypnic, which is fast breathing. Tachycardic, which is fast heart rate. And hypotensive, which is a low blood pressure.
And did you note multiple gunshot wounds?
I did, because I went by the wounds that I saw. And I remember, and it says no exit wound. I wasn't able to find where we thought potentially the bullet had traveled and moved. And that was a concern, obviously, in discussing it with my surgeons. That's why I noted no exit wound.
And could you tell us where you noted the gunshot wounds?
So there was a small dime-sized penetrating wound located in the cranial dorsal left lateral thorax.
And what does that mean?
So that's kind of like on her side, but it would be behind her arm.
Okay. And which arm are we talking about?
Oh, her left arm. So cranial is towards the front of the body. Dorsal is towards the top, the spine. Left is left. Lateral meaning the side of, and the thorax meaning the thoracic cavity, which usually extends from the neck to mid-body. It's where the ribs end.
Okay, and can you tell us what she was diagnosed with eventually?
Penetrating gunshot wounds, tachycardia, which is the high heart rate, tachypnea, which is the high, fast breathing, hypotension, which is low blood pressure, recumbency, because she was recumbent and not able to walk, a hemoabdomen, which is the medical term, it's for blood inside the abdominal cavity, and then a possible hemothorax, which would mean blood inside her thoracic cavity.
Would it be fair to say that she had internal bleeding?
Yes.
And was the bullet, was, in your medical opinion, the bullet the cause of her death?
Yes.
And did you give Mr. Jacobson an estimate as to how much it would cost for the surgery?
I did. I don't remember the exact numbers. It may be, oh, yep, it's in my notes.
And roughly what was the estimate that you gave?
$6,000 to $10,000.
And eventually, are you aware of what actually became of Candy the dog?
Yes.
And what became of her?
She went into surgery, and during surgery, coded and died.
May I have a moment, Your Honor?
Yes, sir.
Did you ever interact with Mr. Jacobson?
I did.
Do you recall his demeanor while interacting with him?
Yes.
And what was his demeanor?
He was incredibly sad.
Thank you, Your Honor. I think I have nothing further.
Ms. Johnson?
Thank you, Your Honor. Good afternoon, Dr. Morris. My name is Andrea Johnson. I am one of Zach's attorneys.
Hi.
So it's your testimony this afternoon that you're saying there was more than one gunshot wound in the dog. Is that correct?
Yes, ma'am.
Isn't it true that you testified in your deposition that there was only one gunshot wound?
I don't remember.
I have your deposition here with me, and it's a little difficult because this is on Zoom.
Okay.
I'm handing a copy to Mr. Timpanic, and I'm going to read to you an excerpt, page 19. Lines 10 through 12. The question presented to you in your deposition, which you had taken an oath to tell the truth before you took your deposition, right?
Yes.
Question on line 10. Did you ever find any indication that there was more than one gunshot wound in Candy? Answer, not that I remember, no. And isn't it also true that you were not, well, let me share an exhibit with you, which would be
okay.
Exhibit 6, the second page. Actually, the third page.
I can see that.
Dr. Morris, do you see the laceration on the elbow of the dog that's depicted in Exhibit 6?
Yes.
And is that what you testified earlier to on direct, that you're asserting that that was a gunshot wound?
Can I look at my record? Because I usually try to write exactly where everything I see.
Well, earlier on direct testimony, you had indicated multiple gunshot wounds, right?
Right.
Okay. And are you able to recall whether or not you assessed the laceration that's on the right elbow of the dog as a gunshot wound?
I believe I thought that was the gunshot wound as well as the one on her side I talked about before.
Do you recall in your deposition that said you were not able to determine the cause of this laceration that's depicted in the photograph?
I mean, I guess I can't even, I guess I can't say what caused it, but, you know, with the history, I assumed it was from trauma from a gunshot, you know, a bullet.
So you don't know that if this laceration depicted in the photograph is a gunshot wound, isn't that correct?
I don't know, 100% no.
All right, I'm going to pull up for you Exhibit 2, a document that's Bates labeled Jacobson 17. up momentarily.
That's okay.
Yeah. Jacobson 17.
Can you guys hear the meowing?
You need to,
Sorry.
you need to feed a cat?
Your Honor, we have no objection to the cat meowing.
We have cat lovers here too.
Okay. I must know he's on camera.
Dr. Morris, can you see the document on your screen there?
Yes, I can.
And I want to direct your attention to where it says right thoracic limb. Do you see that?
Yep.
And for those not in the medical field, they were talking about the right arm, right elbow area, right? I mean, correct?
When you say right thoracic limb, yeah, the right front arm.
And we had just looked at a photograph of that in Exhibit 6, right?
Right.
I want you to look at the section under findings. I'm going to read the second sentence to you there. There is no evidence of soft tissue swelling or metallic ballistic foreign material. Do you see that?
Yes, I do.
So that means that there was no bullet in the right elbow of the dog, right?
Objection, Your Honor. This is improper impeachment. This is Dr. Ellis's medical records, not Dr. Morris's.
Yeah, does she,
Your Honor, these are the records subpoena from Blue Pearl.
There are two Blue
Veterinary.
Pearls, Sarasota and Tampa. This is the Tampa one.
well, I think you can ask her if that description is consistent with her view of it.
Dr. Morris, the sentence I read there, which says there is no evidence of soft tissue swelling or metallic ballistic foreign material, is that consistent with your review of the laceration on the elbow?
Yes.
And do you recall the entry wound being on the front chest or shoulder area of the dog?
It was in her left side. So not really shoulder, kind of behind her arm and shoulder.
If we could turn your attention to Exhibit 6, the first photograph there. Dr. Morris, do you see that first photograph there?
Yep.
And where the pen is pointing, is that the entry wound of the gunshot?
I believe so.
And it's accurate that you did not find an exit wound,
Yes.
but one bullet was removed from the dog, right?
I don't know.
Okay. Do you recall whether you made observations of how the bullet traveled through the dog?
Yes.
And isn't it accurate that the bullet traveled from the dog from front of the dog to the back of the dog?
Yes.
Your Honor, may I have a moment?
All right.
No further questions, Your Honor.
No redirect, Your Honor. Witness is excused with thanks of the court.
All
From
right.
us.
Dr. Morris, let you get back to your kitty.
Thank you.
All right.
Thank you,
I
guys.
was going to ask, is she defense exhibit?
Dr. Morris, you're released from my subpoena as well. This is Attorney Brian Kessler talking.
Thank you. We're signing off here now. Thank you.
All right, thank you.
All right. So what else you got, Mr. Timpani?
Nothing for today, Your Honor.
All right. All right, let me see counsel up here. So, how y'all doing? 9:30 tomorrow. Work with the bailiff, will tell you where to go. We got some work to do before you get here, but no point to you.
But Your Honor, I just thought of something. Our witness is at 9 a.m.
Oh, is that right?
We can make it 9:30 if need be.
Yeah, let's do that.
All right, I'll do that.
Yeah. Okay. So if you don't have any questions, leave your pads on the seat. And you can go with the bailiff.
All right, your rest, next to you.
Mr. Timpani, let's leave the witness set for 9 so we don't have any technical issues, okay? I don't want to have it delayed. So she may have to wait, and it's
Dr. Wendy Ellis.
Ellis. Okay, great. Anything before we adjourn?
No, Your Honor.
Okay, if you have any case law that you want to bring in regards to any of the issues we expect at the close of the case, you expect to rest tomorrow?
I wasn't planning on I was planning on resting on Monday. I thought we were just doing a couple witnesses out of order, and then I was going to see if I had anybody else, and then rest on Monday morning if need be.
Well, I'd like to use the time wisely if we have some time in the afternoon. Well, perhaps we can have the argument, and I can take the weekend to decide what I want to do. But could you be prepared to make the argument?
I don't think so, Your Honor. Obviously, it's very voluminous what we're actually, especially considering we've had motions on it. If absolutely need be, I just think that I'm already preparing for 2 witnesses, 2 crosses, and the obviously directed verdict argument as well.
Well, here's my only concern. I want to make sure that we have the case basically wrapped up by Thursday, so that the jury can take it for deliberations on Friday. And so I want to make sure that we use our time prudently for that, to meet that goal. How do you feel about that, Mr. Kessler?
Your Honor, we would expect to have time after the presentation of the 2 witnesses in the morning, which I don't believe are going to take all morning, and after we make the motion arguments to be able to start our case in chief tomorrow afternoon. Granted, I can understand the court wanted to take the weekend to consider the motions, but I believe that they need to be brought forth tomorrow.
for example, I don't know what additional witnesses Mr. Tympanik may have. I believe he's gone through all the witnesses on his list with the 2 that he's calling tomorrow morning. So I don't know why we're waiting a weekend.
Are you saying you think we'll complete testimony tomorrow by noon?
Mr. Tympanik, I believe with Miss Ellis and what we talked about the other day, Your Honor, or yesterday, with Miss Ellis and Dr. Bonda, Dr. Ellis and Dr. Bonda, I don't believe we anticipated it taking more than 2 hours, correct? So we should be wrapped up in the morning, Your Honor. We can go directly into arguments, and then the defense can start its case in chief tomorrow afternoon.
Well, Mr. Tympanik, because I want to hit that mark, and I don't know what's going to happen next week. What we can do, if we get the witnesses over by noon, we could take an extended break to allow you to prepare for argument, but I don't want to waste a whole afternoon.
Yeah, Your Honor, if need be, depending on how long does counsel expect directed verdict arguments to take?
Bear with me for a second while I think, Your Honor. We have 4 counts. We're going to obviously I would anticipate probably 45 minutes to.
I'm figuring an hour and a half, probably, because I may have some questions too. So what I'm suggesting is, since you're focused on the case, is that we could start the argument like at 3 o'clock. You know, if we finish by noon, we could have the motions at 3 o'clock and take our time.
Oh, and then obviously they have 2 witnesses they still have to call. So then we're talking 8, 9 o'clock.
Correct. I have Dr. Haupt and
That's why my
Mr.
argument, Your
Mulvihill
Honor.
tomorrow.
Well, the only thing I can say is, if you're going to present testimony tomorrow, I don't want to use that time, burn that time up. I can always reserve on your motions, without prejudice to your position. So, yeah, how long do you think your witnesses will take?
I think Dr. Haupt will probably be an hour and a half, and then Mr. Mulvihill, half hour.
Well, you're talking probably the middle of the afternoon before we get there, right?
I don't see us taking the entire morning for the remaining 2 doctors' testimony.
It's not the remaining doctors. I expect a lengthy directed verdict argument and back and forth, Your Honor.
Well, we're going to use the time wisely tomorrow. And if that means you'll have to prepare some tonight for those anticipated arguments, I think you'll have to do that. We typically have those arguments immediately after case in chief closes, so should be a surprise. So, well, let's just work on that plan, and things could change. Just want to see how much time we're going to have at the end of the day tomorrow. And if we have time, I'll take your argument. All right. So we'll be here at 9 o'clock. The jury will be back at 9:30, and we should be good to go. All right. Thank you.
All rise. Court's in recess for the day.